Good morning everyone. Sorry for the slight delay. We had a little bit of a technical glitch. OBS crashed. So, we had to reset, you know. So, good. Yeah, we started recording this time without crashing. So, figured at least I would say hi before we crash a second time. I am, of course, Leonard French, your favorite copyright attorney. Thank you for joining me this morning. Thank you for spending your time with me. And thank you to the 96,000 of you. Oh, great. I don't have my Firefox open now. I had all the tabs prepared for you, and it crashed. So now I have to do all my preparation over again. I don't even remember what I had open. I think we had this open. This is our 96,094 subscribers on YouTube. Thank you all so very much for subscribing. I'm not going to beg you to hit the bell or like watch every minute of my videos. I'm just glad that you're here. That's really whatever level you want to participate at. I'm really grateful for. There might be a session restore in here. Restore previous session. Hey, that worked. We have a lot of fun stories for you today. Today, we are going to talk about the Pennsylvania attorney that totally faked out their client and got caught. I mean, after you hear the facts, how couldn't they get caught? It's a very educational story, and I'm really gonna explain why this is extremely educational, especially to any young or new attorneys out there. But it's also a reminder for all of us seasoned veteran attorneys and more to always eat the crow while the crow is young and tender. We will talk about how Iowa State University denied permission to NORML, the National Organization for the Reform of Marijuana Laws, to use their cardinal mascot and now owes them $1 million or so. We will talk about March for Our Lives. We will talk about SESTA. We will talk about the Nazi pug conviction. We will kind of discuss it. I don't actually know what the actual court ruling is yet, so we're waiting for that. Until we get that, we're just going to discuss it, and maybe you could tell me something. Maybe we'll learn something from everyone. And then we do have a trivia question at the end. I will once again announce our winners from last week. If you did contribute to the trivia question where the winners were announced last week, because we didn't have one in between, I will be contacting you this afternoon with your winnings. So look for my message in your inbox this afternoon. My afternoon. A few hours from now. We have some new videos up on the YouTube channel that are not from the live stream. Facebook was sued by their shareholders over the Cambridge Analytica stuff, and there's a new dog video. So here is a link to the... Hey, that wasn't supposed to start. Here is a link to the Facebook video and the new dog video in case anybody wants to watch them. Don't forget that you can support our channel in many different ways, not the least of which is trying Audible. If you have not tried Audible, we'll talk a little bit about a book that I'm going to recommend later, and there's the Audible trial link. Which, of course, if I'm decent here, I'll remember to put a link down here in my notes for later. So, welcome, everyone. You may notice that my bubble is going on the left side of the screen occasionally. We have some guests joining us today. Brandon, Cerulli, and Steven and Tactical Bra are here, and we'll be asking for their input at various places in the show. So, let's get started. I guess I'll just keep the recording going rather than I don't have to think about it. I won't have to think about it if I leave the recording going. One day we'll have an assistant pressing these buttons, and I can just concentrate on the show. By the way, we are watching some news stories that are developing. Guccifer 2.0 has turned out to be a verified Russian agent, and I do want to cover whatever part of that story I think we can add anything to. I'm not just going to make a video to make a video. Where if I'm only going to make a video about something like that, if I think that there's a perspective I can add to the conversation. We're following the Cambridge Analytica situation. We are working on some stories. We're working on the Stardock story. We're working on the Lexmark case that DJ Gilcrease sponsored. We are working on a different disciplinary complaint. A PA prosecutor created a fake Facebook account to interact with... I just closed Pushbullet. I remember closing it. Oh, that's right, I restarted. A PA prosecutor created a fake Facebook account to friend defendants and more or less illegally communicate. So she was found, or the disciplinary complaint has been filed. She's not been found guilty yet. One that's really important to me, the 5 Points graffiti artists have been awarded $6.7 million for their whitewashed artwork. The property owner who commissioned their work or allowed their work, this was not illegal graffiti. He I think it was a he, the entity painted over the work even though the work was protected by law. And we'll go over what law protects graffiti art, because it's not that simple. It's actually, all artwork is protected by this law, and graffiti is art. So we have the full color artwork too. We're gonna show the artwork, and that's the artwork that was destroyed, and talk about the artists that created it. So that's why I want to do a really good job on that one for you. We do want to talk about the trade war. 1, 2, 3, 4. Let's have a trade war. There's a weird thing going on. I'm not even getting into the politics of it, but there's an interesting perspective that has come up in some of the reporting that I've been reading about, and it does seem like there might be something to the trade war. So we want to talk about that. And again, only if I think that we can offer a unique perspective or add some kind of value to the story. And as I was kind of just going over a little bit before, there's a new New York law that makes it illegal for workers to be required to remain in communication with their company after work. In other words, if their contract doesn't say, you're being compensated for being on call, then you can't require, employees to check their emails and stuff after work. And we have a few more stories in that. But the first story that I think we're going to cover is the March for Our Lives story, which once again everything got reset, so I've got to wait for it to load. So this is a really remarkable story. We have the Parkland shooting, of course, which was a terrible tragedy. And from that, has spawned a whole political movement or social movement or whatever you want to call the movement. David Hogg here is one of the students. He spoke at he spoke to NPR yesterday, and he spoke at the March for Our Lives march in Washington, D.C. Paul McCartney was there. Why are you auto-playing, Mozilla? I just told you not to do this. And Emma Gonzalez was there. She stood silent for 6 minutes and 20 seconds. And I'm not here to talk about it because I think that guns should be banned or that these kids are totally off their rockers thinking they can ban guns. I'm not here to make any points on either side. What I'm here to talk about is the size of this movement, the enthusiasm for this movement, the participation in this movement. We calculated it out yesterday. Approximately 1 out of every 400 Americans. 1 out of every 400. Not 4,000, not 4 million. 1 out of every 400 went to Washington, D.C. yesterday and marched with these kids. That's a lot of people.
It's a big number.
That's definitely more than the Rally to Restore Sanity or Fear from 2010. It's definitely more than the Trump inauguration. Not comparing for, like, you know, dick measuring purposes, but rather just the size of the movement. Like, this is not small. This is not a small movement. And it's actually, it's quite remarkable, some of the things that I'm seeing. You've got all kinds of different creative messages. You've got people of all colors and backgrounds and ages. You've got Washington, D.C. packed to the nines with people. And I don't know, I haven't heard a single report of any problems. It seemed like yesterday went perfectly peacefully. So fortunately, like, nobody can even point to anything odd that happened. What I thought that I could add first was, you know, just remarking on how remarkable the size of the movement is. But I also wanted to kind of call for moderation, and I don't mean moderation of either side. I mean that I see a lot of hyperbole, especially if you go through the March for Our Lives hashtag. You see both sides of it. People comparing the clear backpacks to, you know, trying to juxtapose them and the kids' requests for safety. I see a lot of hyperbole trying to polarize the messages on both sides, that either the Parkland students want to take everyone's guns away, or they're stupid for thinking they can take everybody's guns away. And this is not quite how these movements work. Sure, there are people with those messages in the movement, absolutely. I bet you people who don't care for guns don't really understand why anyone would ever think that it's a right or want to have them. And I bet you people who are so familiar with guns that it's second nature to them are like, I've not done anything wrong. Why should I be punished? Like, this is our Constitution. So what I think is really happening here is there's a whole spectrum of messages. There is no one message on one side and one message on the other. These are not tightly organized groups of people. This is a loosely organized political movement. And so what you should take away from this is not agreeing with any one message based on its message or popularity. Merit would be a good thing, but that's not even the point. The point is that 800,000 people showed up to Washington, D.C. because they're upset about something, and probably another 400,000 to 800,000 showed up elsewhere in the country at the other 600 rallies. And that's not small. These people want to have a conversation. These people want either, some of them, like I said, want to completely ban guns. Other people, like David Hogg, have tried to make clear time and time again, let's see if I can find it here. They've tried to make clear time and time again that he's only after, like, 5 specific things. So it's important to read the transcripts. It's important to read the primary sources. There was an NPR article here. Yes, there it is. And he is mostly pushing for the enforcement of the existing law and the improvement of the digitization of records, closing of loopholes, things like that. He likes to tell people that his father's in the FBI and he's not trying to ban guns. And I'm not here to spread his message either. I'm just talking about, that's, you know, one of the main people who's involved in this thing, one of the students. You know, his message is not a hyperbolic message. So when you pay attention to this, definitely pay attention to all the sources and all the sides and all that. But remember the veracity of the source and really try to dig for what the real message is, and understand that sometimes there isn't a unified message. What's remarkable here, though, is the number of people showing up that are looking for change. It wasn't exactly a you know, cold, rainy day, but it wasn't this, you know, a nice warm day either. So, you know, this was also, having been to the rally to restore sanity or fear, Washington's built for this, but it's also a lot of people. And I'm a person who hates crowds, and I'm terribly afraid of being caught in a crowd. Something bad happened once, and I thought that I would have a problem. I was with my friends, so I went along with it anyway. There was no problem. I was in a crowd of 450,000 people, and everyone was super polite. Anybody bumped into you, they were like, "Oh, I'm sorry." Like, how could you not bump into a million people? Well, there were a million sorries that day. That's just how people were. It was really, really cool. The worst behavior I saw was people climbing on trees or traffic lights to see better. Once in a while, you had somebody who had a little too much energy, might have been like climbing for fun, but that was about it. Like, nobody was making a big deal. It was just a rally. So it's what these people are asking for is a conversation, a meaningful conversation. And to me, a meaningful conversation is not one where you come to the table with your heart and mind closed. You have to come to the table with your eyes open, your heart open, your mind open, and you have to be sincerely and earnestly willing to entertain actual change. You don't have to agree to give up all of your position. You don't have to agree to an untenable compromise. But you shouldn't come to the table closed off from it, though. And I feel like there's a lot of that happening. And again, it's a spectrum, so there's a lot of it not happening, too. It's probably a bell curve. And it's probably a little bit of an inverse bell curve in the sense that the people on the fringes of the one bell curve are probably the people who are the loudest about it on the other bell curve. So there really are probably a good number of those 800,000 people who are not trying to do the worst thing that you can think of. Likewise, I'm pretty sure there aren't, 5 million NRA members who all wish that this whole thing would just go away and they don't want to talk about it at all. I have a feeling that a good number of gun owners, this particular gun owner before you included, want to have this conversation, want the world to be a safer place, and would like to find a compromise that doesn't involve taking away the rights of lawful, law-abiding citizens, while at the same time addresses the problem and makes schools and just life in general safer. There's no reason not to have this conversation. Absolutely none. You can still take, I can still take a position. They can still take a position. The students everyone can still take a position and have this conversation. The problem is that we're not. Our society has gotten to a point where it is just easier to just say your thing on the internet, me included, and not listen to anyone. And that's, like Marilyn Manson said 20 years ago at Columbine, you got to listen to the kids. You got to listen to them. They're the ones who understand and know what happened from their perspective. And the perspective is not invalid just because they're kids, just because they haven't had more life experience. Personally, this is my humble opinion here. Feel free to disagree with me, but if you have been shot at and your friends have been killed in front of you, I think you've been experienced enough to talk about it and talk about what you think needs to be done. I don't mean any authority has to be given to your knowledge of the solutions, but your energy and enthusiasm for a solution should not be diminished because you're young. No, quite the opposite. Quite the opposite. Also, they're forced to go to these schools. I don't mean like, you go to jail if you do kind of get hit with truancy if you don't go to school, do you? So they're forced to go to school. And I know it's not like, the cops are coming to take you away to school, but at the same time, like, the social pressure plus legal pressure is on for you to attend school. So they shouldn't have to attend school, this mandatory thing, and be worrying about whether they've been protected by the adults. Also, us adults are really good at being stupid and covering for it. I'm not blaming any one person, but I've been a kid and I've been an adult, and we're really good at overestimating how much control we've got of things. And we're really good at telling kids that we've got more control over things than we do. Let's stop that. They see that. We've got the internet. They can see that, and they call us out on that, and we discredit ourselves collectively as a group. Like, literally, kids don't trust adults because we say too many incorrect things. People they're directly involved with. So, I mean, I'm not saying, like, any one of us can fix this, but, like, let's all be more conscious that these kids do look up to us as the previous generations and as having control. And maybe we should make clear that we don't have the control. I love to quote Billy Joel's "We didn't start the fire." We don't have the control that they think that we do. Maybe we should stop acting like we do and have the freaking conversation with them, because we don't have the control and we don't have all of the answers. We need to come together and find the answers that work by talking to each other and hearing each other and learning each other's perspective, and then trying to see from that person's perspective. It's hard to do, but I swear when you start practicing empathy, the world becomes an easier place to understand. Also a much more frustrating place. Sorry. That's what I've got to say about that. It was just an important thing I wanted to talk about right away. Anyone in the channel want to comment? Any thoughts?
I think that we're supposed to be, one of the guiding principles of our republic is that the conversation will be allowed. That you can talk about stuff like this. You can't just let it sit by the wayside. So it's really good to hear that, like, an unprecedented number of people have shown that they want to talk about this. Actually, just last night, we actually just had a protest as well over in Elgin, because a lady got shot on the highway. Very similar protest. Just trying to talk about, how can we prevent stuff like this in the future,
Yeah. To tell my one and only story about an actual protest gone wrong, we had a situation at my high school. I don't really need to go into too many details because it really wasn't that terribly interesting. They didn't want to give the kids their pocket change in the cafeteria because the kids were throwing the pocket change. So you can kind of see both sides of this one, right? Like, the administration doesn't want to deal with kids throwing change, yet the kids feel like, hey, that's my money. So both sides are valid in that one. So the kids organized a protest. I helped organize the protest. Our protest made the front page of the local paper in color. I was pretty proud of that. Our protest that I organized, though, was one like I just said. It was a conversation. We went to the auditorium. We were having a meaningful conversation with our fairly new principal, and he was starting to answer our questions. And I shit you not, the doors of the auditorium burst open, and in come the other half of our classmates who hadn't attended the meeting. Shouting, yelling, screaming, chanting, signs and everything. They shouted us all down. Even those of us who wanted and were getting answers couldn't even hear our answers. The administration gave it a few minutes and then had to shut down. They were possibly relieved that they were able to shut it down, to shut down the peaceful meeting and force the not so peaceful protesters outside. And that was the end of that. We didn't really get our conversation. So that's my big concern about this, is if there's too much hyperbole on both sides, which is why I'm a little relieved to see that there was no violence. I'm relieved as a human being to see that there's no violence, but I'm also relieved that the conversation will continue because it wasn't interrupted by violence at the protests yesterday. So let's continue that. The conversation on both sides of this issue needs to continue, and hopefully it will not be overshadowed by some of the louder and more hyperbolic messages out there. So my call is for moderation, and as somebody once told me, much to my chagrin, being in the center doesn't mean that you're always right. It means that everybody has a reason to hate you. Great. But that doesn't mean it's not the right way to go. Anyway, so that's that.
You talked about protection of children and expectation of protection for children going into public schools, but what do you think about how we should police schools? Like saying maybe metal detectors or etc.
Oh yeah, sure. There's the solutions. You know what I'm not discussing this morning is the actual solutions. That's not what this channel or this particular discussion was for this morning. I wanted to remark about the movement and how important it is to have the conversation, especially to kind of remind people that, like, even if you don't want to have the conversation, look at, it's 0.25% of your population, literally, or in the United States, 0.25% of the United States population went to Washington, D.C. Like, that gives me goosebumps. That makes me feel a little emotional. That gives me a super excited feeling for democracy. Our people were fired up by this issue and went and did something. They didn't just talk about it on the internet. That's pretty awesome. I don't care which side of the story you were on. I don't care if you're pro-gun, anti-gun, whatever. It's remarkable that people did this. If 800,000 pro-gun people marched on Washington, I would be equally as stunned.
Yeah, for sure. I mean, if 800,000 people that wanted anything marched on Washington, I would be impressed. And that's definitely a conversation then, right? Because, like, that's a lot of people.
When was the last time we saw a march this big? Wasn't it like the Women's March or something?
Or civil rights, I think.
Ago?
Probably the big civil rights march on Washington in, like, 1964?
No, how big was the Women's March? The Women's March was pretty big. The 2018 Women's March was pretty big.
Oh.
Let me just take a quick look here. It was pretty big. 200,000 in New York City. Approximately they say less than 500,000 in DC and less than 300,000 in Chicago. They're only saying less because the previous march was bigger. It does not seem like they're trying to minimize the numbers. They're just saying that it was less because it was the previous number from the previous year was bigger. But yeah, so that was probably the previous largest march in recent memory was the Women's March. And the only reason that we didn't discuss the Women's March is I just don't feel qualified. Like, I just didn't. It's really remarkable. And I think I did remark that it happened, but I don't feel like I'm qualified to speak on women's issues. I'm happy to listen. I listen on women's issues. And I don't mean that that's like a man's duty is to listen. I just mean I personally feel like I should listen on that one. Okay, stop recording and let's see if we blow up again when we start recording. Yay! We didn't blow up. Real quick, because there seems to be a little discussion on it. There are reasonable restrictions that are allowed in schools. Anything that disrupts the learning environment can overcome free speech, basically. So, and I don't just mean arguably. I mean, like, you have to be doing something or wearing something that is disruptive to the learning environment that can be prevented. And so that means they can prevent T-shirts in public schools that say things They can prevent the T-shirt in public school that says pro-NRA or anti-NRA or pro-gun or anti-gun. They can prevent ones that say, you know, pro-free speech or anti-free speech or something if it's causing a problem. So it's different in public schools. They're allowed restrictions like that. They're allowed to search you on your way in for safety with metal detectors and things like that. That's perfectly allowed. It's not allowed. They wouldn't be able to do that to adults in a non-public school setting. Like if adults had to go to a government thing, they might be able to check them for weapons, but they wouldn't be able to check them, like search them up and down. So basically the same standards as going into your local courthouse. All right, the next story is a much, much lighter story. I love this next story, so I really hope you do too. Oh, that's right, all of my PDFs got closed too. Hang on. We're going to fix this. All of them. For this story, you may thank attorney Jamie Ray Leonetti. This is in the Supreme Court of Pennsylvania, as all disciplinary counsel cases are. And this is a disciplinary action against attorney Jamie Ray Leonetti. There's her attorney registration number. Looks like she's after me. Yeah, I think she's after my number. Upon consideration and recommendation of the three-member panel, the joint petition in support of discipline is granted. On consent, which means she agreed, and she is suspended from the bar of the Commonwealth of Pennsylvania for a period of 1 year and 1 day, and shall comply with our other provisions of some rule of, I forget what that is. And she shall pay costs. This is not the interesting part. This is just wetting our whistle. The panel approves, and let's begin. Petitioner, the Office of Disciplinary Counsel, file this joint petition in support of discipline on consent under Pennsylvania Rule of Disciplinary Enforcement 215D, and respectfully represent that petitioner is the Office of Disciplinary Counsel. Respondent is Jamie Ray Leonetti, born in 1973, admitted to practice law in November of 1999, so she's before me, and has a public office address there. Respondent is subject to disciplinary action because she is a lawyer before the courts of this Commonwealth. Respondent is aware of this open investigation, and in connection with that investigation, respondent submitted a letter, and she agreed to enter this joint recommendation. And she stipulates that the following factual allegations are true and correct, and that she did violate the rules of professional conduct. So all that preparation just means that she agreed to this. Like, this is not disputed. These are undisputed facts. Respondent investigated whether Ms. Cleary and Mr. Cleary, the Clearys, had a basis to pursue a particular medical malpractice claim against the Jefferson Health System, the Doylestown Women's Health Center, and 2 doctors. On February 15, 2014, respondent commenced a lawsuit on behalf of the Clearys in Philadelphia court by filing a precipice to issue a writ of summons. Really quickly, a writ of summons is a little bit different than a complaint. In Pennsylvania, and in South Carolina, I think, I'm not sure. In Pennsylvania, you can begin a lawsuit with a writ of summons, which is literally just the summons, not even the complaint. The summons will list a cause of action, but it's just going to say, like, breach of contract or medical malpractice or something. So you can begin a complaint without filing a complaint. You can begin a lawsuit without filing a complaint by using a writ of summons, which writ is just a word that means you have a proper legal procedure that you can go through, and in this case, the procedure of the summons. The writ of summons gives you the summons. And so that begins the lawsuit. So she's now begun a lawsuit. The lawsuit was scheduled for an arbitration hearing on November 3rd, 2014. The arbitration hearing was rescheduled by respondent. Respondent became employed as a staff attorney with the Disability Rights Network of Pennsylvania, DRN. Continued the arbitration hearing then. It was scheduled till January 9th. And she once again asked for a continuance on January 5th. It was continued again to March 6th. March 6th is the important date. Respondent received a notice of the new March 6th date and advised her client that the arbitration hearing was rescheduled to 10:45 a.m. at the arbitration center on that day. Respondent, however, failed to file a complaint. So she's only filed the writ of summons and only served the writ of summons. On March 5th, respondent sent an email to Ms. Cleary in which respondent represented to her that she had been notified that the March 6th arbitration hearing was postponed and would be rescheduled because the Philadelphia courts were closed the previous day. The March 6th arbitration hearing had not been postponed. Respondent misrepresented to Ms. Cleary that the March 6th arbitration hearing had been postponed and would be rescheduled. They then failed to appear for the March 6th arbitration hearing. The defendants and counsel for the defendants appeared at the arbitration hearing. With the consent of the defendants and counsel for the defendants, the only people there, the lawsuit was transferred to the Philadelphia Court of Common Pleas and was heard by a judge, who then entered a judgment of non-pros, which means non-prosecution, against the Clearys in the lawsuit. The court noted that a review of the docket showed a complaint had not been filed. So when this happens, when you file a lawsuit or start filing a lawsuit and then you fail to do the things to continue the beginning process of the lawsuit, the defendant can ask a judge to throw it out as not prosecuted. Basically, non-pros means not prosecuted. The plaintiff did not do their basic prosecution of the matter, and so just toss the thing out, judge. On March 9th, the court sent to respondent a notice about the order. Respondent received and reviewed the notice. Respondent failed to take any action in response to the notice, as in, like, calling the court and saying, hey, I screwed up, can we fix this? Or admitting to any of the problems that were caused or anything like that. Respondent failed to advise the Clearys about the entry of the March 6th order. And between March 6th, 2015 and March 2nd, 2016, respondent exchanged the following series of emails with Ms. Cleary. In those emails, respondent represented to Ms. Cleary that the arbitration hearing would be rescheduled, that there was no need for an arbitration hearing because the defendants had agreed to settle, that the settlement was $50,000, and the Clearys would receive that sum as a result of the settlement, that respondent was waiting to receive the settlement check in September and November of the same year, that respondent was communicating with defendants and the insurance carrier about the delay in receiving the settlement check in October and November of that year, that respondent had received the settlement check but a problem arose over how it was made payable in December, that respondent was waiting for the check to clear before distributing the funds in December and January, that the check had been deposited into an account maintained by the Disability Rights Network in December and January, that a portion of the settlement proceeds would be used by the Disability Rights Network to mail checks to satisfy outstanding bills the Clearys owned to a high school and a community college, that the issued check had been made payable to a tuition company that processed payments for the high school to cover the outstanding bill they owed to the high school, that check had been returned that respondent had arranged for Smart Tuition to receive the tuition payment electronically, that various circumstances arose that result in a delay of issuing the settlement check to the Clearys, that mail delivery problems resulted in a delay receiving the Cleary check, that transportation problems hindered respondent from being able to deliver the Cleary's check, that the Clearys would be receiving an additional $5,000 because of the various problems that arose, that respondent had arranged for the Clearys to receive their share of the settlement proceeds by means of a wire transfer to an account maintained by the Clearys. Ms. Cleary made an appointment to meet with respondent finally on March 7th, 2016 to discuss the delay. The March 7th meeting was canceled because of a medical emergency involving respondent's husband. On March 7th, respondent and Ms. Cleary spoke on the telephone. The respondent finally admitted to Ms. Cleary that respondent had not settled the Cleary lawsuit, but it failed to advise Ms. Cleary that the Cleary lawsuit had been dismissed, and the reasons for its dismissal. On March 8, 2016, Ms. Cleary sent respondent an email asking for an explanation why it was not settled. On March 8th, respondent replied asking for a little more time for a complete response. On March 9th, Ms. Cleary sent respondent an email inquired if a malpractice case had been filed on her behalf because she was unable to locate the case. Respondent replied, among other things, stating that respondent would provide her with the docket number when she was back in the office, and claiming that the reason the Cleary lawsuit had not settled was due to a breakdown of discussions when the hospital placed a different lawyer on the same case in a sort of a last-minute move. Ms. Cleary replied, among other things, stating that she was still trying to process everything and the disaster it has left my life in with bills and my son, and inquired if her case was done or if the case was still being negotiated. On March 9th, respondent replied a second time that she would continue to negotiate and she believed there could still be a good outcome. Again, respondent failed to advise Ms. Cleary that the Cleary lawsuit had been dismissed. Respondent misrepresented to Ms. Cleary that it was still possible to negotiate a resolution of the lawsuit that could result in a good outcome. On March 10th, respondent sent an email to Ms. Cleary that contained an email that respondent had received from the 1st Judicial District confirming that respondent had filed legal paperwork electronically to commence the Cleary lawsuit. On March 10th, 2016, Ms. Cleary sent respondent a reply that thanked her for the March 10th email. Again, respondent failed to advise Ms. Cleary that the lawsuit had been dismissed. During the period that respondent sent Ms. Cleary a series of emails that contained those misrepresentations, respondent also sent several emails to third parties that contained misrepresentations. Wood High School received misrepresentations that DRN had sent payments on several occasions to Smart Tuition. Bucks County Community College received emails that misrepresented that the Clearys were expected to receive settlement proceeds next week, and that they could be applied to satisfying the outstanding bill towards the outstanding bill owed to Bucks County Community College. With respect to Smart Tuition, they received misrepresentations that a check had been sent and had been returned, and that additional information was necessary to resend the check. By her conduct, alleged in paragraphs 8 through 51 above, respondent has violated the following rules of professional conduct. And just so you're clear, what we're about to read are the Pennsylvania rules of professional conduct, but these are virtually the same in all states. They do vary a little bit. Some states have slightly different advertising rules or whatever, but these are all based on the model rules of professional conduct, which law students learn pretty heavily in law school, and all lawyers are required to comply with pretty much at all times. So Rule 1.3 states that a lawyer shall act with reasonable diligence and promptness in representing a client. Rule 1.4a3 states that a lawyer shall keep the client reasonably informed about the status of the matter. 1.4b states that a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions. Rule 4.1a states that in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. And 8.4c states that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So, yes, it's true, lawyers are not allowed to engage in dishonest, fraudulent, deceitful, or misrepresentative conduct. Believe it or not, we can't lie. So then here's the specific joint recommendation for discipline. And this gets super interesting too. Especially if you remember that we talked about the judge who stole the cocaine, and if you remember why he was disbarred instead of just being disciplined for some shorter period of time, it was because he didn't make a certain showing of evidence of a mental health disorder. Petitioner and respondent jointly recommend the appropriate discipline for respondent's admitted conduct is a suspension for 1 year and 1 day. Respondent hereby consents to that discipline being imposed upon her by the Supreme Court. And attached to this petition is an affidavit stating that she consents. In support, it is respectfully submitted that these are the following several mitigating circumstances. A board-certified psychiatrist prepared a report in which the respondent was diagnosed with complex post-traumatic stress disorder, a condition that results from chronic or long-term exposure to emotional trauma over which a victim has little or no control and from which there is little or no hope of escape. A redacted copy of the report was appended as Exhibit A. Another letter, from their counsel, a licensed clinical psychologist provided a letter as well. Another psychiatrist has stated that she has been compliant, respondent has been compliant with treatment recommendations and their prescribed medications. That respondent has established, the court agrees that respondent has established that there is a causal connection between her misconduct and the mental health condition, which satisfies the Braun conditions that you might remember from the previous video. Respondent has admitted engaging in the misconduct. Respondent has cooperated with petitioner, as evidenced by respondent's admissions and consent to receiving a suspension. And respondent is remorseful and understands that she should be disciplined, as evidenced by her consent and to receiving the joint discipline. One aggravating factor is respondent's record of discipline consisting of a private reprimand with a 1-year period of probation for having violated similar rules. In that reprimand, respondent failed to diligently pursue an employment discrimination and wrongful termination case on behalf of a client, failed to provide the client and the client's relatives with accurate information when they inquired about the client's legal matter, and to provide the client with information that she needed to make an informed decision. Made multiple misrepresentations to the client and the son-in-law regarding the case. The conditions required her to continue to take prescribed medication, undergo counseling, and file quarterly reports from her therapist. The sanction recommendation relied on another report by her doctor. In that report, the doctor had concluded that when she had engaged in the misconduct, she was suffering from a major depressive disorder. Significantly, respondent's misconduct in the current matter involving the Clearys overlapped with the aforementioned 1-year probationary period served by respondent. Then they go over a case, the Office of Disciplinary Counsel versus Mark D. Colazzo, in which a joint petition, support of discipline on consent, recommended a suspension of 1 year and 1 day for having failed to timely advise a client in a lawsuit in federal court that it had been dismissed on statute of limitations grounds. So that's super interesting. And the reason I wanted to bring that up to you today, besides the fact that that's super interesting, was that this is a generally a good idea for life. If you must eat crow, if you have screwed up, eat that crow while it is young and tender, or surely you will eat it while it is old and tough. And trust me, she would be going through a lot less of a hassle if she had admitted these things way back in the beginning. In fact, she probably could have undone some of the damage if she had said, I missed the court date, I screwed up. Judge, please dismiss us without prejudice, or give us a chance to refile or something, or sanction me or whatever. But now she probably owes $55,000+ or something to these people, or is facing a lawsuit of about that size or something. So that's just terrible. I can't imagine just going that far with a lie to a client. However, as a person who has faced depression and PTSD, I can say that they do have that effect, and my recommendation to anyone suffering from PTSD or depression is to be very careful not to overload yourself. You have to take time for your healing. You must take time for self-care, as they say. The problem is if you have family like I do, I'm not knocking them. They're very nice people, but they were a little bit too perfection-y and a little bit too... They didn't allow space for recovery, and that can only just exacerbate mental conditions. So if Ms. Jamie Ray Leonetti, respondent here, if she has complex PTSD and another major depressive disorder, or maybe those are both the same diagnosis, I don't know. Either way, they're along the same lines. If she is going through that, she super needs to limit how much work she takes and how much she subjects herself to. This is a kind of awakening thing that what's happening in America. If the rest of the world, if you're not familiar with this, our country doesn't really recognize PTSD and depression as super good causes for limiting work or not working or recovering or whatever. We often society, whatever, often stigmatizes it and calls people either lazy or dumb or something because they don't just snap out of their depression. Why can't you just be happy? I've literally had friends say to me, just cheer up, just put on a happy face. And yes, that is good advice for some things that are not major depressive disorders. Yes, sometimes people are concentrating on bad things, and simply by not concentrating on bad things, you can make your life better. These are the parables of the two wolves. These are the parables of the two monks. Why are you still carrying her? I put her down miles ago. Which wolf wins? The one you feed. Though these are great parables, but these do not overcome an actual mental health disorder. A mental health disorder of that magnitude is akin to breaking a major bone in your body, or possibly even several major bones in your body. And no citizen would see a person with a broken leg and wonder why they're not winning races. But a lot of citizens will see a person with a major depressive disorder, and instead of trying to understand why a person is not operating at 100%, they assume that they're lazy. Even people who eventually find out that a person has a major depressive disorder still sometimes go and say, well, just snap out of it, or you just, pour yourself into your work. That will make everything easier. I had that said to me when I was depressed in high school because my girlfriend had cheated on me. My father had lost his business because of steel. That was the steel prices that was happening 20 years ago. And I got super depressed and I wasn't functioning well in school. And my professor said to me, and a very nice guy, a wonderful professor, like, these are not bad people. These are just, this one particular thing is misguided. His advice was just to pour myself into my work because at least I would get some work done. And that's great advice, except that the major depressive disorder made it very difficult for me to pour myself into really anything. Most of my days were spent staring at the ceiling, laying in bed, or staring at a screen, which is more something we do now. The internet wasn't as big back then, so you really didn't have like a Reddit or a Dig or a news.google to look at. So, or even a Wikipedia. So a lot of my days when I was super depressed were really spent just kind of like staring at the ceiling. It wasn't even like fun wasn't fun anymore. It wasn't like if I was lazy, I'd be going out and having fun and doing stuff in place of work. Or, even then that could still be a psychological substitute for, procrastinating, trying to put off, and there's some mental block. But I mean, major depressive disorders don't make you lazy. They make you non-functional, which are two completely different things. So my heart goes out to this person, this attorney, because although she's definitely not supposed to be perpetuating those lies, of course, that's terrible. And I hope that her client is able to recover something from either the circumstances of the case and a judge maybe allowing things to be reopened, or maybe she can go after this person's insurance if they carry it. Not every attorney has to carry insurance. For example, yours truly does not carry insurance, and as long as I notify my clients properly, that's perfectly allowed under Pennsylvania law. So every client that signs with me signs a clause that says they know that I don't carry insurance, and that's fine. Insurance is very expensive, especially for young and inexperienced attorneys. No duh, right? But how are you supposed to survive? So fortunately, the state of Pennsylvania doesn't require me to have insurance that I can't pay for, or if I'd have to pass along charges to my clients. And I've had the conversations with them. I've said, if you want me to be your attorney and you want me to have insurance, like, we can talk about that, and I'll go and get insurance, and I'll have to charge you a little bit more. Of course, I won't charge you like the whole price of the insurance, but some proportion thereof for the number of clients that I carry. And it's several $1,000s a year for coverage that only covers you in particular circumstances. So I don't take those kinds of risks, and so I don't feel like I'm ever going to be in a situation like this respondent found themselves in. If I make that kind of mistake, wow. Not having insurance is also a huge motivator not to make that kind of mistake, by the way. Kind of like those arguments about having helmets in the NFL. Like, of course you want to have helmets, right? But as they make them better and better and better, people can just hit harder and harder and harder. So are you really making it safer, or have you just increased the number of concussions? It's, I don't know. You have to argue both sides. Like, you have to have the debate and figure out where the numbers fall and what's most important to you. So I was saying something before about eat the crow while the crow is young and tender. Here is the book. How to Start and Build a Law Practice by Jay Foonberg. Yes, that's a link to my Amazon affiliate account. And of course, you're also welcome to get that or any other book as an audio book at audibletrial.com/lawfulmasses. We get a commission for you signing up for the Audible trial. By the way, you don't have to pay for the Audible trial. It's a free 30-day trial. I listen to audiobooks all the time. Currently, I'm listening to one on logical fallacies, and still finishing up the Bill Browder Red Notice book, which is, it's gripping. It's sometimes a little bit too much. Like, it's just like, oh my God, I don't want to hear any more about how horrible Russia is. So he's really good. It's super good. I don't mean like I just mean like sometimes I just need to just like unplug for a second. Any of the anyone on the channel have any thoughts or questions?
Hello. Can you hear me?
Yes.
Okay. Question from SJK, I think. Can our clients go after the lawyer for malpractice in addition for trying again on the lawsuit, or one or the other?
Yeah, basically both. They can't double dip in the sense that they can't receive an award twice. They shouldn't be able to be, I'm going to consider it unjust enrichment, so they shouldn't be able to be enriched by a second shot at recovery. So they definitely should still have the right to recover something, at least from the attorney, possibly from the attorney's malpractice insurance. I'm not sure how that works. Maybe the malpractice company doesn't cover when the attorney does something like this. Maybe they only cover mistakes This seems a little more willful than a mistake. It was motivated by the mental health issue. I have no problem believing and agreeing with that. I'm just saying it was more than a mistake. It was something that the attorney did actively, and so I don't know how the insurance company looks at that. I have never made a malpractice insurance claim, so I don't know. And I mean, I also don't have personal experience, is what I'm saying. So there should be a chance at recovery here. What's unfortunate is that the couple, the Clearys, has to get a different attorney and then go after this attorney. Hopefully the Disability Rights Network, since she was doing this through the Disability Rights Network, hopefully they carry insurance and they just eat the cost. I hate that. That's horrible, but yeah. This is weird. It's weird when you make a mistake and then try to cover it up like that. I've made mistakes in cases before. I even missed a court date once, but like the very first thing I did was call and be like, "Hey, my fault. I missed it. Here's what happened. I'm sorry. What do I do?" And the judge wasn't nice. The judge was seriously pissed off at me. Thought that I did it on purpose. So, like, this is not a light thing to miss a court date. It's so, you know, if you miss a court date, Jesus Christ, you got to call. You got to call and tell somebody and be like, "No, I didn't mean it. I really didn't mean it." And she apparently didn't do that. That looks really bad for her and her client then. It looks like she filed a lawsuit and then didn't have anything to back it up and so just didn't show up or something. It's just weird.
We have a question from Mandalorian Lawyer. Nice name. What CLE requirements does Pennsylvania have for ethics and professionalism?
We have 12 hours of continuing education required a year, and I think 2 of those hours have to be ethics credits. And 6 of the total hours can be remote. So 6 have to be in person and 6 have to be remote, or can be remote. Me personally, I will be at the American Bar Association's Intellectual Property Law Spring Conference at the Crystal City Marriott in Crystal City, Virginia, which is just outside of Washington, D.C. So if anyone wants to meet up on April 19th or 20th, it would probably be the evening of April 19th, because I'm only staying one night. It's only a 3-day conference. Only 2 days is the 12 hours of credit. And so I'm only coming for the 12 hours of credit. I only need like 9, I think, credit hours. But there's some super cool topics that we're talking about there. Also, I think I want to do a live show. Maybe I'll try and find someone to interview, and we'll do interviews at the IPL Spring Conference live on the Lawful Masses channel. What do you think? We'll talk to lawyers from all over the country.
That sounds great.
We'll come up with, here's what we'll do. We'll do 3 simple questions. We'll give them the questions ahead of time and say, you know, if you're interested in coming on our show, here's the questions. You know, I'll still have to ask them, but, you know, we'll ask the questions and then go from there. And either we have a short conversation, long conversation, works, doesn't work, we'll have fun. I will probably be wearing a silly hat outside of the educational parts of the conference center. I will not be doing anything disruptive or live streaming or making a ass out of myself, or even just trying to call attention to myself during the actual educational sessions of the conference. However, out in the hallway, all bets are off. We'll see what happens. I've seen people doing all kinds of things out in the hallway. I've seen people doing their blogs and their vlogs. I've seen people having full-on conference calls with clients. I've seen people doing work. I've seen people playing video games. It's just a little bit of everything. Lawyers are unique people to begin with, and this is a conference of the most unique lawyers that I know. Creative lawyers. Lawyers for intellectual property, for patents, trademarks, and copyrights. And a not insignificant number are copyrights. Probably a good third or more of the people are seriously interested in copyrights. And so a lot of my generation and previous or younger generations will be there as well. So it'll be cool to see what younger lawyers are up to these days. And I think we're meeting Blackleaf. I think I'm going to get to meet Blackleaf in person.
Ah, sweet. Can't wait.
When did we get the 795 bits from Salem Adams? Thank you for that.
I was about to go ask you if I could read those, actually.
Please, go ahead and read those.
Cool. We have a Twitch Prime subscription from Kyle Stay and UOFA511. We also have one from MissTax8, subscribed 5 months in a row.
Wow.
We just received a 5-month subscription from Binis Mani, I believe.
Oh, Benizmani, thank you.
That was a full subscription, not a Prime. Some cheers from me that I don't want to read out. Salem Adams cheered 795 bits. Manitoban Misanthrope cheered 5 bits, saying, "Yay, free bits." Somebody's watching ads on our behalf, it looks like. Theas JK subscribed using Prime. 5 Trode subscribed using Prime. Rabid Dolphin 87 and H Goel also subscribed using Prime. And another one from Manitoba Misanthrope, 5 bits.
Thank you, everyone, very much. That's a lot. Our next story is also kind of a lighthearted one. It goes to Trademark. I know a lot of you are very interested in Trademark. A lot more of you than I anticipated. Whenever one of these weird Trademark cases comes up, you guys have a lot of attention for it. I'm amazed. I don't find trademarks to be as fascinating as some people do, but this one's a pretty interesting and fascinating trademark situation. I'll give you a quick primer, and then we'll look at 3 short legal documents, and we'll go from there. So this involves the Iowa State University. They have a mascot. It's a cardinal. And the National Organization for the Reform of Marijuana Laws wanted to, well, the local student chapter wanted to put the cardinal, the ISU cardinal, onto a t-shirt that was produced by Normal and had, of course, Normal's logo on it as well. That t-shirt looks like this. Or at least this is what I was able to find. I hope that's the only t-shirt. There could be more than one. It's upside down. I'm sorry. It's not the greatest picture in the world. But the point here is there is a cardinal in place of Normal's O. It's a red shirt with the ISU colors. And, Normal is in Normal's colors. So, what is the problem here? Well, the school denied permission. After initially granting permission, the school denied permission to use the school's trademark in connection with the marijuana, the pro-marijuana message. And so the local chapter, the ISU chapter of Normal sued, actual students from ISU sued, and the state attorney general sort of quickly figured out that they weren't going to win. So this is a letter from the Iowa Department of Justice to, I think, the judge. We have reached an agreement to settle this lawsuit with the Iowa State University. The lawsuit alleged various violations of the First and 14th Amendments rising out of ISU's refusal to permit their use of the ISU logo on t-shirt designs that also included a cannabis leaf. The U.S. District Court for the Southern District of Iowa sustained plaintiffs' claims, and that decision was affirmed by the United States Court of Appeals by the 8th Circuit. By the United States Court of Appeals for the 8th Circuit. The 8th Circuit also awarded attorney's fees. Thus, the only issues on remand to the district court are damages and additional attorney's fees for work at the trial court level. Then they agreed to a payment of $150,000 in attorney's fees to these two law firms. And I thought that was a good place to go into this. This is the United States Court of Appeals for the 8th Circuit decision in the case. Iowa State University grants student organizations permission to use its trademarks if certain conditions are met. The ISU student chapter of Normal had several of its trademark licensing requests denied because its designs included a cannabis leaf. 2 members of the student group subsequently filed this action, alleging various violations of their First and 14th Amendment rights. The district court granted plaintiff's summary judgment motion. Defendants appeal, and we affirm. ISU is a land-grant university, 36,000 students, approximately 800 officially recognized student organizations. Student groups often create merchandise that contains the group's name and ISU insignia to generate awareness about the group's cause or attract members. Student groups may use ISU's trademarks on merchandise if the trademark office, the ISU trademark office, determines that the use complies with the general guidelines for university trademark use. ISU's trademarks include ISU, Iowa State, as well as I want to say logos for some reason, as well as logos such as the school's mascot, Cy the Cardinal. At all relevant times, okay, whatever. Normal is an officially recognized student organization. It is a student chapter of the National Normal Organization, and its purpose is to reform federal and state marijuana laws. In October 2012, Normal submitted a T-shirt design to the trademark office at ISU. On the front that had Normal ISU on the front with the O replaced by Cy the Cardinal. On the back, the shirt read, "Freedom is normal at ISU," with a small cannabis leaf above Normal. The trademark office approved the T-shirt design. Then, on November 19th, the Des Moines Register published a front-page article about the marijuana legalization referenda in Colorado and Washington and pending legislative efforts in Iowa. The article quoted Normal ISU president as saying the group's political efforts to change. The article quoted the Normal ISU president regarding the group's political efforts to change Iowa's marijuana laws. He said, "Montgomery said his group has gotten nothing but support from the university. He even got approval from the licensing office to make a Normal T-shirt with the ISU logo." At 8:50 a.m. on November 19th, Zimmerman provided ISU's public relations office with the following statement. The university's trademark policy and student use guidelines allow officially recognized student organizations the ability to use Iowa State's trademarks as long as they observe the proper guidelines. Groups, including Normal, may use any of the university's indicia as long as they seek review and approval from the licensing office, which they did. This does not mean that we take a position on any of the groups we represent. Later that morning, an Iowa House Republican caucus staff person sent a formal legislative inquiry to ISU's state relations officer asking whether ISU's licensing office approved the use of the ISU logo on the Normal shirt. The request was forwarded to the ISU president. At 2 p.m., Senior Vice President for Student Affairs and other administrators indicated that ISU was getting some pushback regarding the article. He wants to place this on the president's cabinet meeting discussion agenda. The reason it was on the agenda was because it was getting pushback. If nobody had ever said anything, we didn't know about it, it didn't appear in the register, we'd probably never have raised it. At 3 p.m., another email asked whether ISU could revoke the approval without more damage. If we gave approval to something that was inappropriate, they said, we might want to consider revoking it, but we could just make the problem worse. I was only asking for his advice. At 3:19, a reply said, we need to deal with this. What were they thinking? They testified that my experience would say in a state as conservative as Iowa on many issues that the T-shirt was going to be a problem. On November 20th, Dale Woolery of the Governor's Office of Drug Control emailed and called the head of ISU's government offices about the article. His email indicated that he was curious about the accuracy of the student's statements cited in the report, and perhaps the process used by ISU to make such determinations. Leith testified in his deposition that anytime someone from the government staff calls complaining, yeah, I'm going to pay attention. We are a state entity, he's chief executive of the state. On November 21st, the head of ISU's Public Relations Office responded by stating that normal ISU's use of the trademarks was permitted under the policies governing student organizations. This procedure was being reviewed, however. On November 24th, Normal ISU requested permission from the trademark office for another order. They decided to place this reorder on hold until after the president's cabinet meeting. He testified that he did not order the trademark office to hold reorder approvals, but that Zimmerman testified that she could not think of any other time that the trademark office had played. And Zimmerman testified that she could not think of any other time that a trademark office had placed the student group. Wow. And Zimmerman testified that she could not think of any other time that the trademark office had placed a student group request on hold. The president's cabinet meeting took place on November 26th. After discussing the article, the group agreed that the guidelines had to be changed. They met with members on November 29th and expressed concern that the group's use of their trademark caused confusion as to whether ISU endorsed the group's views regarding the legalization of marijuana. They then informed the group that the trademark office would not approve any t-shirt design that had used ISU trademarks in conjunction with a cannabis leaf. They also told the group that it was required to obtain approval for any future designs prior to submitting the designs to the trademark office. They also told the group that they must get permission. They also told the group that they were required to obtain approval. They also told the group that they were required to obtain approval for any future designs from Madden and Hill directly prior to submitting the designs to the trademark office. Zimmerman testified that, to her knowledge, this was the first time ISU had ever imposed a prior review procedure to a student group's trademark design application process. Normal's reorder of T-shirt design number 1 was rejected on December 3rd. On January 16th, the trademark guidelines were revised. It now said, designs that suggest promotion of the below-listed items are prohibited. Dangerous, illegal, unhealthy products, actions, or behaviors, drugs, drug paraphernalias that are illegal or unhealthful. Madden indicated that this revision to the trademark guidelines was done as a result of a number of external comments, including interpretations that the T-shirt developed, indicated that ISU supported the Normal ISU advocacy for the reform of marijuana laws. After the trademark guidelines were revised, the trademark office rejected every Normal ISU application that included an image of a cannabis leaf. In July 2014, plaintiffs filed this action. Defendants argue that the district court improperly concluded that the plaintiffs have standing. We review brand new whether the district court concluded properly that the plaintiffs had standing. This is going to be an interesting one. Why would you think that students at your university don't have standing? That's a weird one. That's a weird one. Let's see about this. Defendants argue that the district court, standing is a judicial prerequisite that must be resolved before reaching the merits of a suit. Under Article 3 of the U.S. Constitution, a plaintiff must show an injury in fact, a causal connection between the injury and the conduct, and the likelihood that a favorable decision can redress the injury. So you must show an injury, a causal connection between that injury and the actual conduct that you're alleging, and a likelihood that a favorable decision, not necessarily a likelihood that you get a favorable decision, but a likelihood that a court can issue an order that addresses your injury. So your injury has to be remediable. It has to have a remedy. If you're suing somebody and it's a completely empty Pyrrhic victory, the judge will say you don't have a remedy at law, therefore you don't have a case. You must have an actual case or controversy that is remediable at law. So, plaintiffs bear the burden of proving these elements. Defendants argue that plaintiffs lack an injury because plaintiffs are asserting Normal ISU's right to free speech, not their own. To establish an injury in fact, a party must show that he personally has suffered some actual or threatened injury. as injury is defined in 42 U.S.C. 1983 only as a deprivation of rights, privileges, or immunities secured by the Constitution and laws. We, the Eighth Circuit, therefore conclude that plaintiffs have suffered an injury in their individual capacities and therefore do have standing to bring this action. Defendants next argue that the district court erred by granting plaintiffs summary judgment on their First Amendment claim. We review a district court's grant of summary judgment brand new and consider the facts in a light most favorable to the opposing party, the non-moving party. The district court's grant of summary judgment is only appropriate when there is no genuine dispute as to any material fact, and the moving party is entitled to judgment by law. Not just by fact, but by law. We must determine whether the district court properly applied the qualified immunity doctrine to this dispute. Qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Qualified immunity does not apply to claims for injunctive relief. Qualified immunity is not an issue here because this appeal solely concerns plaintiffs' requests for injunctive relief. Next, we must determine whether defendants violated plaintiffs' First Amendment rights. If a state university creates a limited public forum for speech, it may not discriminate against speech on the basis of its viewpoint. A university establishes a limited public forum by opening property limited to use by certain groups or dedicated solely to the discussion of certain subjects. A university's student activity fund is an example of a limited public forum. ISU created a limited public forum when it made its trademarks available for the student organizations to use if they abided by certain conditions. The defendant's rejection of normal ISU's designs discriminated against that group on the basis of the group's viewpoint. The state engages in viewpoint discrimination when the rationale for its regulation of speech is the specific motivating ideology or the opinion or the perspective of the speaker. Every viewpoint discrimination claim requires by its very nature the purposes or motives of government officials be determined. Viewpoint discrimination can be justified only if the government demonstrates that its regulation is narrowly drawn and is necessary to effectuate a compelling state interest. That right there is known as strict constitutional scrutiny. Can only be justified by the government showing its regulation is narrowly drawn and necessary to effectuate a compelling government interest. All those words are very important, and if you want to become a constitutional lawyer, you'll be memorizing that many times over. The defendant's discriminatory motive is evidenced by the unique scrutiny defendants imposed on Normal after the Des Moines Register article was published. For example, after the article had been published, defendants placed Normal's reorder of the t-shirt design on hold, despite the fact that the trademark office had already approved the design. Defendants claim that the hold on the reorder request was not specific to that group because they also placed a hold on a trademark request by the Association of Malaysian Students. Zimmerman indicated in an email, however, that if the group were to tell administrators when it needed the plaque, the trademark office may be able to move that review forward. The plaque for the Association of Malaysian Students. ISU did not offer Normal ISU similar flexibility. Moreover, Zimmerman testified that she could not recall ever placing another student group's reorder request on hold. Another example of the unique scrutiny imposed on Normal ISU is that the group was required to obtain approval from Madden and Hill for any future designs using ISU trademarks prior to submitting the designs to the trademark office. Zimmerman testified that to her knowledge this was the first time ISU had imposed such prior review procedure. Defendants argued that this type of scrutiny was not unique to Normal ISU because the hockey club was also subject to additional oversight. The university had imposed additional scrutiny on the hockey club because the club had mismanaged funds and misrepresented itself as an intercollegiate sport, however. Normal ISU had not engaged in similar malfeasance. A third example of the unique scrutiny normal ISU received is it was the only student group to have its trademark application denied for fear that the university would be endorsing a political cause. Defendants pointed to 6 examples of design requests that were rejected to avoid the appearance of an endorsement. All of these examples are in opposite, however. 4 of the designs were rejected because it appeared ISU was endorsing a corporate logo. Another design was rejected because it suggested that a club sport was an official athletic department sport. The final design was rejected because it appeared that ISU was endorsing the views of the Students for Life Club, but the trademark office approved the design once the group made a minor change to the design. Defendants' actions and statements show that the unique scrutiny they imposed on Normal's trademark applications were motivated by viewpoint discrimination. After the Des Moines Register article was published, ISU stated that any student group could use the university trademarks as long as they observe the proper procedures and follow the specified design standards. After the government's office and an Iowa House Republican caucus staff person contacted them regarding the article, however, the defendants immediately took measures to contain the political controversy by revising their trademark guidelines. And this continues a little bit. I think we've gotten the point. The defendants then go on to argue that Defendants then argue that if they did engage in viewpoint discrimination, they did not violate plaintiffs' First Amendment rights because the administration of trademark licensing should be considered government free speech. The Free Speech Clause restricts the government's regulation of private speech. It does not regulate government speech. When the government speaks, it is not barred by the Free Speech Clause from determining the content of what it says. The government speech doctrine does not apply if a government entity has created a limited public forum for speech. As noted above, ISU created a limited public forum when it made its trademarks available for student organizations to use if they abide by certain conditions. The administration of its trademark licensing regime therefore did not constitute government speech. For these reasons above, we affirm the judgment of the district court. Great. So how do we get to $1 million? That's this document. Plaintiffs seek an award of attorney's fees and costs. There is no remaining dispute that plaintiffs are the prevailing parties in this action. The court is left with the task of determining what is a reasonable fee. They go on to cite that a reasonable fee involves an analysis of the number of fair and reasonable hours billed against a reasonable billable hour rate. This lodestar calculation is regarded as reasonable compensation. There is no dispute in regard to the number of hours billed on behalf of the clients. Rather, the remaining dispute focuses on some of the rates. The reasonable market rate is usually the ordinary rate for similar work in the community where the case has been litigated. The court is thus tasked with determining the relevant legal market. Plaintiffs argue the relevant market is Washington, D.C., where most of the plaintiffs' attorneys practice. Defendants argue that the defendants argue that the relevant market is Des Moines, Iowa, where the matter has been litigated. In a case where the plaintiff does not use local counsel, the district court is not limited to the local hourly rate if the plaintiff has shown that, in spite of its diligent good faith efforts, he was unable to find local counsel and willing to take the case. Upon a determination of the relevant market, the burden is typically on the party seeking compensation to demonstrate a prevailing rate for similar services in that market. The court has examined the application for fees and costs in light of a stipulation of the parties as well. Excuse me. There is no challenge to the necessity or reasonableness of the hours expended by the parties. There is no dispute regarding the hourly rates claimed, nor is there a dispute regarding the claimed costs. Finally, the fees and costs incurred in connection with litigating the pending fee application were a matter of stipulation. Having argued the relevant legal market is Des Moines, the defendants challenged the fee claims for lead counsel and another attorney, both of Washington, D.C. The defendants assert the hourly rate claimed by another attorney is the appropriate market rate, which should be the highest rate allowed. In support of the claimed fees, counsel have provided the court with affidavits regarding their qualifications, the hourly rates they normally charge, and the reduced rates they are seeking in this matter. The record does not contain additional evidence regarding prevailing fees for like work in either market at issue. Based on the court's experience, the rate of $475 per billable hour utilized by the local counsel is on the high end, but is not excessive for an attorney of his experience, skill, and expertise for this particular area of practice in the Des Moines market. The professional stature and reputation of the other two attorneys are both apparent to this court and are unchallenged by the defendants. Indeed, the local counsel's skill and defendants. Indeed, it is the local counsel's skill. It is the local counsel's skill and experience that defendants utilized in arguing plaintiffs cannot make the necessary showing that they could not obtain local counsel with the ability and willingness to take on the case. Quite the contrary, the local counsel is extremely able and qualified to took the case as local counsel. While local counsel's credentials in the area of First Amendment litigation are beyond dispute, his substantial experience has been gained largely in representing news organizations and media companies. The list of clients and representative cases clearly supports that conclusion. Lead counsel has similar generic credentials in the First Amendment area, but with a material distinction. He has been involved in a number of cases across the country representing First Amendment rights of students in an academic setting and has written extensively on First Amendment issues. Thus, while both counsel were qualified to provide the necessary representation, it was the foreign counsel, the Washington, D.C. counsel, Mr. Corn Revere, that came to the case with substantially extended experience, specifically applicable to the case. The defendants argue that $302 per billable hour is excessive in comparison to the rates charged for work in this jurisdiction. The court does not have a basis for concluding this on the available record. In the absence of an available record, and based on the foregoing analysis, the court concludes that the stipulated request for attorney's fees in the amount of $570,233.55 is well within the range of fair and reasonable fees for the services provided in this matter. Further, the court concludes that the stipulated request for cost in the amount of $28,000 is also a fair and reasonable request in this litigation. Accordingly, the court hereby confirms and preserves its prior orders and judgment, including the January 22nd injunction, etc., enter judgment in favor of plaintiffs against defendants for fees and costs prevailing for $598,218.17. And I think that was just for the appeal. Then the costs of the local case were then... Oh, that was the costs for the district court. So then when you add in the costs of the appeal, it hits just under $1 million. I don't have the exact calculation in front of me, but that's remarkable. So look at how quickly that decision was made, and it cost $1 million worth of attorney time, and well, $800,000 worth of attorney time and $150,000 worth of damages to plaintiffs for such a simple thing. Like, you're a university, you've got to have lawyers on staff. Why didn't you talk to your lawyers about whether you're allowed to change your policies in response to the state legislature making inquiries? I mean, honestly, it sounds like a bunch of people were just spooked by the article and the fallout that those were going to have from the state legislature because, oh my God, the university approved something that the legislature disagrees with. Heaven forbid that we have a disagreement between a university and politicians. Like, that's not going to happen, like, every day. But heaven forbid. So now we instantly have to go to quelling the free speech under the auspices of marijuana's bad, so we can't endorse that. It's interesting that they went there so quickly over this. This was super not an issue. Nobody was going to misunderstand ISU's involvement with marijuana, except for the thing that the normal person said. They said what they said sounded an awful lot like the university was endorsing it. It wasn't because of the trademark. It wasn't because of the T-shirt. It was because of what he said. He said, "Look at how much support we got from the university." And what he really meant was, we got procedural approval from the university, who is required to give approval to everyone. basically.
Just basically blown out of proportion, right?
It got blown out way out of proportion real quick, and it ended up being an actual civil rights violation. And so Normal and their chapter gets $150,000, and the attorneys get about $800,000.
Well, it's a nice paycheck for the lawyers.
Well, they worked hard for it. They really, when these people get paid $500 an hour, they we're not talking about people who have to like go look stuff up for 3 hours. The guy's probably done enough work that he goes, okay, well, this case, and this case are the applicable ones. Probably assigns it to a lower paid paralegal to do the work, and his bill might only be a few tens or 100 hours or whatever for the actual discussions and work on the actual case. Whereas we're not talking about like he's not drafting the lawsuit like character by character for $475 an hour. That's typically not how that's done. Especially when you're talking about organizations that are as large as these law firms, they'll usually have staff to prepare those things, and then the attorney will spend an hour reviewing it. So yeah, that'll add $475, but it won't be 5 hours of drafting. It'll be 1 hour of review plus 4 hours of maybe an $80 an hour person drafting.
And they actually end up making more money that way because it means that they can handle more cases, right?
Yes, they end up making more money that way because they can handle more cases, and they end up also observing their rules of professional conduct, which literally say you can't charge an unreasonable fee. I'm not even allowed to go charge a client an unreasonable fee if they agree to it. If I charge somebody too high a fee, and they later on figured out that, wait a second, I paid my lawyer way too much money, they can sue me or file a complaint, and they can try to get some of that money back. So now it's a difficult prospect because an unreasonable fee that somebody agreed to is going to be a difficult thing to prove, but there will be a line where it's too much, and the state assumes that the lawyer does have some sway or some power over the person because they have a silver tongue. The silver-tongued lawyer can talk their way into any client, and it's partially true. I won't deny it that one of the art forms of being a lawyer is talking yourself into the representation. That's kind of the salesmanship part of it. But because it's one of these information disparities where our job is literally to have information that you don't have, and our job is to make sure that you have all the information that you're supposed to have, so you can't just let the lawyer like one-sidedly use that for their own gain. They have to provide all the information to the client too.
Is that why you often provide discounts to your clients, because you're a one-man operation?
No, I provide discounts to my clients to attract business that. So you understand I've got a couple negatives going against me. Even though I have very good reviews, even though I am somewhat experienced, and even though I'm at the cutting edge of copyright law, or at least my niche in copyright law. We're not allowed to say specialization, but I can say niche. In my niche in copyright law, like the BitTorrent file sharing cases, what I don't have going for me is I'm not part of a large firm. I don't have 5 other attorneys working with me or under me even. I don't have insurance, for example. I don't have staff. I'm a solo. I don't even have a paralegal or a secretary. I don't even have a person answering my phones anymore. Well, first, because there's been this huge problem with spam phone calls, but second, I don't really have a need for that anymore. I'm not doing that kind of business at that kind of volume. I take stuff on I sometimes offer my clients a discount, sometimes, when I want the work and I know that I'm at a slight disadvantage to get it. If there's competition for the work and I can cut $100 off my price or half price for the Imagos matter. So I charged half price for the Imagos matter, not just because I wanted it, but also because I knew I was going to be asking for your money, and I didn't feel it was right to charge you an enormous amount of money and then not get the case done. So I knew that really no matter how much money was being donated, I was going to have to complete the case, and so I figured why not just make it fair? I'll make it an amount of money that makes it look like I'm making a sacrifice too. I was making a sacrifice. I could have made double the money. So I made a little bit of sacrifice. You guys donated. The Imagos case was taken care of. That worked out, but in all truth be told, I was probably on the hook for the case, whether or not you paid for it. Like, I might not have been able to get involved if nobody paid for anything. But once we got started, if the donations just stopped and we only had a couple $1,000, I was probably still on the hook for the case. So, fortunately, we had pretty much all the money that we needed. The money hasn't covered all the expenses, and I still have that as a video I want to make for you, is the finishing up the Imagos case. Because the case is obviously closed. It's obviously been more than 90 days now, and so everything's closed. No one has heard from defendant that in a way that I think affects anything, and so I think it's time to finally close it out. So we'll do that too. Maybe next week we'll do a maybe next Sunday's live stream we'll do a closing the Imagos case. Ooh, maybe not on April 1st. Maybe.
Oh,
maybe
shoot.
not.
Next Sunday is April 1st.
On April 1st. Next Sunday is April 1st.
That's
Also,
Easter as
my
well,
birthday. My birthday is next Sunday. My birthday is next Saturday. Easter is next Sunday. So we might just have like a more lighthearted show next week, or next Sunday.
Sounds good.
So I don't expect. I know that like. So, I was a Creaster for a while. I was kind of on the outs with the religion. I'm still not, I don't consider myself a religious, God-fearing person anymore. However, I have all the respect for people who answer the question of mystery and knowledge in the universe with there could be must be, whatever, a higher power. I have all the respect in the world for that, so that's no problem. And Easter is one of the 2 major times a year that you really, really want to go to church. So, no offense, I was one of them too. For the first 23 years of my life, we went every Sunday. Every Sunday was church. When I left the church, I still went back on Christmas and Easter because it made Mom happy. And then eventually, Mom, I sort of came around, I think, a little bit and realized that I wasn't really making me happy. And I wanted to spend my holidays not getting dressed up for church and having awkward conversations about where I've been and why I'm not at the church anymore. So, we just finally decided that we don't do that anymore. But yeah, Easter's a really important holiday for Christians, so I would expect there to be a dip in viewership next week.
Oh yeah. We can just have fun. Maybe I don't know.
All right, so I want to open up. Hang on. There we go. I want to open up this next story for a discussion for all of our panelists here. That's Brandon and Steven in Tactical, and Cerulean. I know you don't like to speak on stream, but if you decide you want to say anything about this, you're welcome to as well. Also, Cerulean, thank you for the killer hat. This is awesome. This is the Nazi pug conviction story. And I know, now that I've said that word, we're instantly demonetized, right? Demoned. So, I'm not going to go into, again, politics of whether it's okay to make Nazi jokes. What I want to go into, well, a few things. First, it's always important to know the law of the place where you are. I remember the one from my generation about 20 years ago where a student was beaten with a cane in Singapore for vandalizing something. I forget the exact circumstances. I don't even remember if the student was terribly guilty. I think they were, but they ended up being lashed with a cane, with an actual, like, sugar cane, like a bamboo stick, basically. Like, smacked, like bloodied with it. And that was the punishment in Singapore. And there was a huge uproar in America about how we have to do something to get this person out of their country because look at how backwards they are. Well, that's not quite how it works. Countries are sovereign, and if this was a known law and he should have known about it and he violated it, well, that's one strike against the whole thing. That doesn't mean that a law is not unconstitutional. It doesn't mean that a law is not unfair, but it does mean, like, you should know better. If you go to Russia, where there are some anti-gay laws, or you go to the UAE, where there are some both anti-homosexual and anti-fraternizing laws, and I mean fraternizing in an intimate sense, you have to know that. Like, just, I'm sorry. Like first things first, you're going to a dangerous place if that's your thing. Like, if you're going to break that law, it's the dangerous place for you. You have to know that. Now, he lives here. Nazi pug guy, Count Dankula, lives in Scotland, I think, within the jurisdiction of the Airdrie Court. And they have some laws that are a little bit different. The judge said that his joke of teaching his girlfriend's pug to do a pause out gesture when he said various Nazi phrases was more than a joke. It was offensive, it was hate speech, and he was convicted of this offense last Tuesday, I think it was. So I'm certainly not endorsing the joke. However, I do think it was just a joke, and no matter how much you're offended by the joke, my natural American free speechness wants to say, you can't put people in jail or fine them or punish them for saying something stupid. And I'm pretty much sticking to that. I'm not really going to be straying from that in this conversation here. So I mostly wanted to have a conversation about this. Was he really punished for the pug Nazi salute? Or was it more so like the overall longevity of the thing, the effort that went into it, and the sort of stick-to-itiveness that he put into the joke? Like, you know what they say, you have to stick to the joke. You have to own your joke. You can't, especially if it's like a time-based joke, or, you have to commit to the joke. So maybe he committed to it too much in the judge's opinion? Or do you think that the judge is just overbearing, doesn't understand, has no sense of humor on this issue? Or do you think the judge is just a judge and has to interpret the law, and this is what the law in Airdrie says, and so he's guilty? I don't know. That's a tough one. What prevents a group of people, any group of people, what prevents us from being offended at the conviction and saying, this is obviously several logical fallacies deep here, but what prevents us from being offended and saying that someone should be prosecuted for our offense at either, the whole situation or something or whatever? What if somebody who made a video about the thing, what if we say that we're offended by their video? In other words, there's a slippery slope argument that if you go down this road, if you start to restrict people's freedom of speech, that you're going to have to be selective about it, and you're going to be restricting people's freedom of speech on arbitrary criteria, not on equal and fair criteria.
Well,
so I want to hear from you guys.
Well, I'd like to know what he said. Did he say Sieg Heil or something? And then the dog responded?
Yeah, so we have YouTube here. Let's look it up. I'm assuming that the actual video is down now, but let's see, there's probably a mirror or something. Here it is. It's 3 minutes and 23 seconds long, and I will, I guess, just disclaimer everyone, if you don't want to hear what's in this video, which is going to be joking references to Nazi salutes and stuff like that, please turn away.
The Count Dankula Nazi pug video to beach. What link?
Okay, maybe.
Girlfriend is always ranting and raving about how cute and adorable her wee dog is. And so I thought I would turn them into the least cute thing that I could think of, which is a Nazi. Buddha, do I gas the juice? Do I gas the juice? Mum will gas the juice, son. Do I gas the juice? Do I gas the juice? Come on, gas the juice.
So far, it looks like he's taught the dog to get excited at a particular phrase. And the phrase he has taught the dog is gas the juice.
Do I gas the juice?
Oh.
Gas the juice.
Terrible.
Oh, I heard some Mario scream in the background there.
Wow.
It's time to get up now, Buddha. It's time to get up. Do I gas the juice?
Now he's showing the dog watching a Hitler speech.
Sieg Heil. Sieg Heil.
And now
Sieg Heil.
the dog is doing a
See Kyle.
Like a paw handshake gesture to see
Gas
Kyle.
the Jews.
All right, we get it. It's kind of a one-line joke, kind of the same thing over and over again. So we get it. Assuming that that's it. I don't really want to play more of it, but assuming that that's the joke. What about that requires jail time or a fine? I'm a little unclear.
The problem
I don't think
here-
Go ahead.
I said I don't think that that's a problem unless it's publicized, which it was. I mean, like, if you want to do that in your own home, fine. But if you want to share that with the world, that's a different story.
Okay. So maybe that's the place where it crossed the line for the judge too, is not that it happened in the first place, but that it was published and then viewed. I mean, this was viewed millions of times. It's now, basically another example of the Streisand effect. They don't want this to be offensive. Well, guess what? Now everyone's going to see it. So you called. I mean, I'm not quite the same scenario. They weren't trying to hide it, but they were trying to say you should never publish this. And so in so doing, more people are going to see this published now.
Yeah.
And I don't mean a small number. I mean like an order of magnitude more, like 10 times more.
I also think an issue here is location.
Of course, you're in Airdrie, Scotland.
Yeah, if this was done in America, I mean, the worst that could happen is somebody would condemn you, right? But you're not going to be convicted for something like this because, at the end of the day, I mean, unless you're making threats towards people, this is free speech, right?
Yeah.
But in Scotland, it's a lot different. There is no free speech per se in the UK, and you can be jailed for something like this in the UK. So
yeah, I'm not saying I agree with their law, but that is their law, and unless you're going to be the cause that undoes the law, you need to be prepared for that. Like, you seriously need that's like climbing Mount Everest. You basically need months of preparation and thousands of dollars. And if you're not ready to do that, you should know your laws and not violate them. Like, even, I mean, like a good example is going back to the marijuana discussion. Not the trademark part, but just literally marijuana. Like, a lot of people do not feel that marijuana requires the kind of jail time that has been visited upon that offense in the past. But that does not mean that I'm ever going to recommend someone in an illegal state, start smoking up and blowing it in cops' faces so that they can challenge the law. That's stupid. You're going to get a criminal record. You're going to have to, fight your thing in court. You're probably going to lose. You're probably not going to be the one that undoes the law. And even if you are the one that undoes the law, it doesn't mean that you get pardoned right away. It means that you get to be a victim of the law and then go to the governor and the legislature and say, please change this. And if it changes, maybe the governor will pardon you. And what, the 200,000 other people or 2 million other people in your state who have been convicted of minor marijuana offenses? So it's not a small issue, is what I'm saying. Undoing the free speech problem that led to this conviction is not a small issue. And so I feel really bad for the guy. I don't feel as bad in the sense that at least his punishment does not seem to be... What's on the table seems to be 6 months in jail and a few £100 fine. Usually, and I say usually from my experience, I have no idea in Airdrie, Scotland. Usually judges don't throw people in jail for this kind of thing. It should have to be worse. The judge took some time, I think it was 2 weeks from last week, so maybe next week sometime, week after this coming week, we'll know what the actual sentence is. Maybe the judge will do something like a suspended sentence. I don't know if that's a thing in Scotland, but we have a thing in America like a suspended sentence where the judge suspends the whole case and says, I'm going to find you guilty. You're going to be sentenced to 6 months in jail and a £500 fine unless you come back in a year and everything's still good and you haven't done this again and nobody's upset with you. And in a year, if you've completed whatever these terms are that I'm setting out for you, then I will just simply dismiss your charges. that's something a judge has been able to do in the past, and I wouldn't see any reason why this judge couldn't either. It's more of like an inherent power of the court than an actual law.
So I'm going to keep this short and sweet because I realize my microphone is buzzing, and I apologize for that. But the UK actually has precedent for similar situations like what you just mentioned. Very recently, they legalized, recently as in five years or so, they legalized homosexuality. And they did retroactive pardons for anybody who was convicted in the last 100 years for public homosexuality. Unfortunately, that doesn't...
And Alan Turing.
Yeah, Alan Turing was one of them. And unfortunately, that does not offer any consolation to the people who died.
No.
And were in jail for it. But this is a thing that happens sometimes. So
yes. So, you know, and that highlights the case of Alan Turing, why it's important that we are vigilant before people are convicted of things that shouldn't be crimes. Because Alan Turing was simply gay, and he went to jail for it.
I think in this case, I'm a little bit worried about the unintended consequences of convicting the YouTuber, in the sense that from his perspective, you know, he made a joke. Is it insensitive? Is it tasteless? Whatever, we can have that comment. But now there's this criminal charge against him, and a reasonable reaction to that is to be really angry at the limits that are being put on your speech, at a huge amount of negative consequences for what was supposed to be funny. And, you know, there's been talk of Alex Jones and some other alt-right people sort of courting Count Dankula to... Am I saying that right?
Yeah. Yeah, I think it is Count Dankula.
Yeah. In terms of saying, you know, look what happens when people are too sensitive, when people try to take away your rights for the sake of looking morally superior or whatnot. And I think it gives fuel to people who you might not otherwise like give fuel to. Like if Alex Jones and his politics or whatever can take this and get fueled by it, by this relatively sort of, I don't want to call it an innocent situation, but he wasn't actually advocating
it's more benign
than Jewish people. Like he wasn't actually advocating for that.
So you have to look at intent.
In the States, we often look at this kind of thing like, well, why didn't you just turn off the offensive program? If you didn't want to see someone say something offensive, then the moment that they start to offend you, why don't you just change the channel? Like that's how we look at it here in the States, is that if he's being offensive and you don't like it, just ignore him. Why would you subject yourself to that? Like if I'm in a bad mood, I have a subreddit. I'll talk to you about my dirty little secret, my dirty little habit. When I'm feeling particularly like schadenfreude about the world and I want to see like somebody else, you know, whatever, I go and look at the Roadcam forum on subreddit, or on Reddit. That's the Roadcam subreddit on Reddit. And where else would a subreddit be but on Reddit? What the hell? And it's it's kind of a double-edged sword, because if I'm watching a video that's like got some justice in it or whatever, I get really excited about that. But if I'm watching one where like, you know, some jerk gets away with it, then I'm like super upset. So like I feel like my little bookmark to the Roadcam subreddit is like a "Do you want to be angry today?" subreddit. It's like a are you sure you want to be angry today? Like Red says in the 1970s show, or in that 70s show, is that what you want to do today? You want to fight? When his wife asks him if she looks pretty.
So, I think a point to be made here is, our country was founded on the principle that you should be allowed to say what you want within reason. The UK was not founded on that principle, right? But I think if they're ever going to have that principle, then something needs. This is the kind of situation where somebody the population can rise up and say, "This is what we want."
Yeah.
You know.
Well, they generally believe in human rights, and I would say this is a human rights thing, a human right to not be thrown in jail for your views on things or the jokes that you make or the non-violent things that you do, basically. Like, it's one thing if I am taking an action that is affecting someone else. If I'm making loud noise at 2 o'clock in the morning and my neighbors can't sleep. You know, it's benign, but it's also not helping. Is his joke so unhelpful that it's causing actual damage? I don't think so. I would really need to see, like, a psychiatrist or psychologist put together a causal connection between person A saying something offensive and person Z, which I'm using for effect, you know, all the way down the line, but it could be as simple as person B, hearing it and saying, I've been so hurt by that that I now need compensation and this person needs to go to jail.
Or
I cannot imagine being in a situation. The only time I can really think about that is if you are a person who has a medical condition, like PTSD that we discussed earlier, and people know about it, like your employer knows about it and does things that exacerbate it. Maybe that's some kind of negligent or intentional infliction of emotional distress or something. That's about the closest I can think. So if you had a person who had PTSD from them or their parents being involved in concentration camps or the whole Nazi situation, you know, or their life was affected by it in some traumatic way, and they see this joke and they get seriously triggered by it, I get that. That's still one step too far removed for me. You can still just turn off the video. No one has forced you to watch the video. This is not a Clockwork Orange situation where someone is trying to retrain your brain by holding your eyeballs open, strapping you to a chair, and playing videos in front of you.
right.
You clicked on a video and watched the offensive pug video and then said, let's go call the police. Or however this
And
happened.
let's take this to the extreme and say this man made a video where his pug was doing things in reaction to Nazi stuff, and then a bunch of people saw this video and like there was a resurgence in the Nazi party. Is he responsible? Like, this is clearly a joke. He's clearly just having fun. You know, I don't think he's a Nazi. Do you think he's a Nazi?
I don't think he's a Nazi. I don't think that. I also don't think that's quite what he's being prosecuted for.
That's true.
Copper Hamster brings up the point that it could be that the entire country of the UK is suffering. Well, country, the entire nation state that is the UK. That's not even the right word either. But you get what I'm saying. The entire organization that is the UK might be suffering from PTSD because they were actually bombed in World War II by the Nazis and the V2 rockets, etc. So, you know, they have a different law because they experienced a different thing. Just like David Hogg and the Parkland students have a different perspective because they experienced a different thing.
I still wonder if jail time and sort of that legal remedy is the best way to handle the situation, because now you're going to make people defend Nazi jokes, and isn't it about why some people felt that joke went too far? And isn't it better to sort of fight speech with more speech in an effort to grow empathy and to understand each other's perspectives better? I'm not sure that throwing him in jail helps the situation. I'm not sure that that's why that law was created. I don't know if this situation was really what lawmakers had in mind. And I don't know if anybody feels safer, if anybody feels the society is improved by having a YouTuber who made an insensitive joke go to jail.
What seems to me to be happening is you have an offended person or persons that sort of get their own individual, like, vindication that, like, they were offended. They get validated for being offended. what does this solve? Like, so they're just going to be more offended the next time because it worked this time. I don't see how this helps anything. Again, if you disagree with him, don't watch his channel. Don't subscribe to him. And, you know, if he does say something super stupid that's more akin to a actual call to violence or something, sure, definitely pay attention to him. If he's doing things that are this close to the line, maybe he really is, as someone said here, a racist, or, you know, I think there were several more colorful words for it, but
that's how capitalism works. That's how it should work. I mean, if you do something bad, then people
the UK
will just
is not
stop,
capitalism,
you know.
But yeah, I agree with you.
I mean, I've just done a little bit of research into the British view of Nazism, and it's really a cultural thing. I mean, we have parties here that are self-declared Nazi parties, like in America, and nothing is done about them because they are allowed to say that, like here. But in the
they're not allowed to take actions. But
right,
yes.
right. In the UK, they have done everything in their power to stomp any party that claims to be of Nazi heritage. Like, I've just done a bunch of research, and pretty much everything that could have even been resembling a Nazi party was stomped out in the 1980s, 100%. And nothing is allowed to research. So this is like, I think they're just really, really afraid of the word Nazi and what that means. You know what I mean? Okay. So it does seem like
they are much closer to Germany than pretty much anybody else except those European countries in between. Belgium, France, Netherlands. Which were the countries that were, I mean, they were the ones that Germany took over. So that's an interesting one. We're probably not going to be publishing this on YouTube. I just wanted to discuss it. It's an important thing in the news. It deals with free speech, and I thought it would be cool to discuss it. The final topic for the day. Hang on, let me cycle my recording. Hopefully it won't crash. Yay! So the final story for this morning, I want to talk about SESTA. SESTA is a new law in the U.S. that purports to make certain types of activities more illegal on websites than they used to be. Don't worry, I'm not avoiding the language. I just want to be precise with it. This is H.R. 1865 before the 115th Congress. This was just signed by the Senate, I think. It has been approved by the House and the Senate. Yes, latest action, Senate. And it is now basically on the president's desk waiting for a signature. This is referred to as the Allow States and Victims to Fight Online Sex Trafficking Act of 2017. I forget what SESTA stands for. Any help there?
Yeah, give me a sec.
It says that Congress has found the Communications Decency Act of 1996 was never intended to prevent websites, or was never intended to provide legal protection to websites that unlawfully promote and facilitate prostitution, and websites that facilitate traffickers in advertising the sale of unlawful sex acts with sex trafficking victims. That Congress has found that websites that promote and facilitate prostitution have been reckless in allowing the sale of sex trafficking victims and have done nothing to prevent the trafficking of children and victims of force, fraud, and coercion. And Congress has found that clarification of such section is warranted to ensure that such section does not provide protection to such websites. It amends Chapter 117 of Title 18 U.S. Code, Section 2421, to say Whoever, using a facility or means of interstate or foreign commerce, or in affecting interstate or foreign commerce, owns, manages, operates an interactive computer service, or conspires or attempts to do so, with the intent to promote or facilitate the prostitution of another person, shall be fined or imprisoned for not more than 10 years, or both. So that's 10 years under this new law for running a prostitution website, basically. Whoever, using a facility or means of interstate commerce or foreign commerce or affecting interstate or foreign commerce, owns, manages, or operates an interactive computer service with the intent to promote or facilitate the prostitution of another person, and promotes or facilitates the prostitution of 5 or more people, or simply acts in reckless disregard of the fact that such conduct contributed to sex trafficking, shall be fined, titled or imprisoned for not more than 25 years, or both. Then, any person injured by reason of a violation of this section may recover damages and reasonable attorney's fees in an action before any appropriate U.S. District Court. The court shall order restitution for any violation of subsection B2, which is the acts in reckless disregard of sex trafficking. It shall be an affirmative defense to a charge of violating A or B1 where the defendant proves that the promotion or facilitation of prostitution is legal in the jurisdiction where the promotion or facilitation was targeted. So that gives the states are allowed to make prostitution legal, and therefore that would not be an offense. Let me see if there's anything else in here.
Just so you know, SESTA stands for Stop Enabling Sex Traffickers Act.
There you go.
And it's often paired with FOSTA, which stands for Fight Online Sex Trafficking Act.
And then they have some other findings here and enable the law, but that's not really at the heart of the law. So what do we think of that? I know there's some huge concerns about this. Many are saying the law conflates sex workers and sex traffickers, but we did see some details there. The sex traffickers have to deal with 5 or more people or be running a website in reckless disregard of sex trafficking that's happening, actual sex trafficking. Some people are saying that the law makes sex workers less safe. As an example, Craigslist has shut down their personals section completely while citing this law, and the Sex Workers Outreach Project is against it. So here to help us understand this is our own sex researcher. No, I'm not kidding. I present to you Tactical Bra. Welcome, Tactical.
Thank you.
Would you like to tell us a little bit about yourself and whatever you want to say?
What would I like to say about myself?
And you can take your time. I'm not gonna, if you uhs and ahs and things, whatever. Like, I know this is not something that you've typically done for us before, so please take your time.
Yeah, so I have a university degree in psychology with a minor in sexuality studies, and as part of that sexuality studies, I've befriended a lot of people who are sex workers. I'm aware of a lot of the debates that go on, and both from sort of an academic point and also the lived experiences of people. And I went to grad school and I focused a lot on sex research. And part of that, again, is keeping up with this news. So I have a little bit of an interesting perspective specifically from the sex workers that I know and their experiences as consensual adult sex workers who are who feel empowered by their jobs, and they have a lot of concerns about this legislation.
Can you expand a little more on that? What have you heard in your circles as a reaction to this law?
So this law focuses a lot on online sites, and that is really scary for sex workers to have those sites taken away from them, because it's one of the ways that they can easily screen their clients. They can talk to each other and have bad date lists and say, don't take on this user. Clients can build up a reputation, where I have friends that have, their policy is you either come with a recommendation from another girl on the site, or she'll do a real name verification. And so having recommendations from other girls on the site is one of the ways that they can increase their safety. But if you have a website that is hosting sort of multiple girls that are doing, and I'm saying girls because I'm mostly familiar with the female side of it, but it applies to men as well. These sites as havens and ways to network and communicate with each other enhance safety. And it also allows people to get away from sort of the pimp or the brothel type structure and be more independent and entrepreneurial. And you're taking away those sites largely because from the looks of it, they don't really discern between, adult consensual sex workers versus people who are not choosing this, who are underage, who are being trafficked against their will.
And just for reference, what's on the screen right now is Craigslist's response to this. This is anytime you go to a Craigslist personal page, Craigslist personals, which includes strictly platonic and casual encounters, like everything, you get this, which is that they won't jeopardize their other services by keeping personals online, so they're taking them offline for now. So that means that these people who use this service for that kind of sex work are going to have to go elsewhere or use other services that are not subject to this law. And some of these services are fairly robust, is what I'm hearing. They're useful for these, even for safety and health.
Mm-hmm.
I think that's going to be disastrous in the long term.
There's actually another bill that was introduced in Rhode Island that you might want to know about. The bill, it requires all ISPs to charge a $20 porn unblocking fee, which would go to the state to help prevent trafficking.
Okay. I don't know how well that's going to go, but if that passes and there's no challenge to it, then I'll consider that remarkable. That should be challenged and should not pass.
Yeah.
But this, I don't see how this would be overtly illegal or overtly unconstitutional or patently unconstitutional. Patently meaning obviously or on its face or showing, whereas latent would mean like lingering underneath the surface, unseen. In the United States, sex work and sex trafficking is generally illegal, and you may have noticed in the language that they used, we'll go back and look at this real quick. In the language that they use here, whoever using interstate or foreign commerce in or affecting interstate or foreign commerce. This is the only way that the U.S. government, the federal government, can make this law is under the Commerce Clause. I hadn't actually been prepared to discuss the Commerce Clause today, but I know enough about it. We should be okay. The Commerce Clause describes the enumerated power listed in Article 1, Section 8, Clause 3 of the U.S. Constitution of Congress. The clause gives Congress the power to regulate commerce with foreign nations and including the several states and Indian tribes. So that right there, that little grant of power has been read to give Congress all sorts of huge powers to regulate anything that just touches interstate or foreign commerce. Even some gun cases have been decided based on federal law because of interstate commerce, because of the Commerce Clause, the Interstate Commerce Clause. So that's how Congress gets the right to do this. So it's not like this is inherently illegal and is going to be struck down by the first challenge, in my humble opinion. I also think there's now a problem with repealing this, because which congressman or woman is, or congresswoman is going to want to repeal the anti-sex trafficking bill? That's a tough one. So someone's going to have to really show how this bill hurts people, or we can basically hope for one possible outcome that is a good outcome. We do have something in the U.S. called prosecutorial discretion. Prosecutors don't prosecute every single criminal offense. Not every speeding driver gets pulled over, let alone that they couldn't do that, even if they wanted to, but not every speeding driver gets a ticket from a speed camera or something either. This is just not the way we enforce our laws in the U.S. They are selectively enforced, and the question then becomes, are they fairly selectively enforced? Are they selectively enforced fairly? In other words, are they selectively enforced based on non-discriminatory criteria? In other words, like, we pull over 10% of speeding drivers because we only have cops to do that, like, rather than saying we only pull over drivers, who have a certain skin color because that's just our policy. So they are allowed to make that kind of selective enforcement, and that's basically, very simply, called prosecutorial discretion. In this case, the scope or the breadth or the width of the law, the net that the law grabs, is pretty wide. So it does encompass even the website owners that might facilitate a regular one-on-one prostitution scenario, and it regulates them and punishes them the same as a person who is facilitating the sex trafficking of underage, non-consensual persons, which, in my humble opinion, are two different offenses. Now, the trouble with the law is that it gives the power to do all that, up to 10 years or 25 years in jail, up to a certain fine and all that. But the silver lining is that there's no guarantee that prosecutors will actually use this law to go after every single website operator who happens to have a person commit a sex trafficking offense on their website and doesn't know about it. This could just be used to go after pages like websites like Backpages.com or Craigslist Personals when used for that kind of thing. But the other half of this is, what about when sites are used for sex trafficking and they aren't typically for that? What if my Discord got used for it? What if Craigslist Personals got used for it? What if an email operator's site got used for it? What if Tinder got used for it? Not to go into any gory detail here, but even I have been solicited for prostitution on Tinder. And that's not a fun thing to have to be like, hey, I really like you, I want to go out with you, whatever. And she's like, don't forget to bring a tip for me. I'm like, what do you mean? She's like, well, I want, $60 if you want to have sex with me. And I'm like, what the hell? Like, this is Tinder. This is not Backpages. This is not like some underbelly of the dirty, seedy underbelly of this is Tinder. Like, you're not supposed to have to get paid. You know what I'm saying? So it's odd that this law would encompass even stuff like that. That if someone could show that they had been injured on Tinder. For example, if I decided to use this law and that solicitation thing happened to me, I could sue Tinder using this civil thing in the law in the law here. This civil recovery. Any person by reason of a violation of 2421A(b), which is a website owner that acts in reckless disregard. I make the argument that Tinder has acted in reckless disregard, and boom, I've got a valid lawsuit. Whether or not Tinder can, they still have to, they'll be able to show whether or not they really did act in reckless disregard, hopefully, but they're now within the discretion of the prosecutor. And one, I can sue them civilly, and two, the Attorney General or the whatever can come after them for the alleged violation. That's just a regular old dating site if their site is being used for prostitution. And it does not say that it has to be the, large amounts of prostitution. If you are a website owner and you are not the prostitute, it looks like you fall under B. You are not so in A, it looks like a person could get 10 years for being an actual prostitute. B, it looks like you can get 25 years for facilitating prostitution on a website as you now become the sex trafficker. That's my reading of it. You've contributed to sex trafficking. Do they have a definition of sex trafficking in here? I haven't seen one.
No. Generally, prostitution and sex trafficking are considered the same when it comes to these sorts of laws.
Okay. So even if you traffic in your own prostitution, you could still fall under a law, or at least find yourself having to defend yourself from this law.
Yeah, sex trafficking, I believe usually it would be someone in a quote-unquote pimp scenario, so that you are marketing the girls out.
Right, but what if I'm a website operator and I host, let's say I'm Craigslist, and I have many perfectly legitimate things on my website, but then I also have a forum for personals, and I use a lackadaisical approach. I have a hands-off approach to trying to discourage people from using Craigslist personals for prostitution. It's hard. It really is hard. I mean, like, half the people that want to do that anyway are good about not coming out and saying it. Like, so it's already a little bit difficult. And not that I have lots of experience with this or anything. I have tried to date, and unfortunately you can find all this stuff while you're trying to date. It's just out there. So,
and I think Camel Spit brings up a really good point in terms of the amount of information that has to be sifted through on these sites, that if you're asking Facebook and Twitter and Tinder to manage user-submitted content, they have to come up with a system to filter out anything that could potentially be related to prostitution. And I mean, that's a really tall order for big sites because they can't afford to have a human look through it. So now you're getting into those heavy-handed, automated, artificial intelligence things that we've had lots of problems with those in the past.
And the LiveJournal case, which you might remember from last year, is the one where LiveJournal lost its DMCA safe harbor, its copyright safe harbor, because it over-moderated. So what if, in trying to moderate your site to prevent sex trafficking, courts now say that you are paying enough attention to the site that you should also be liable for its copyright content that you discovered while you were looking for the sex trafficking offenses?
So yeah, if you take a hands-off approach, it's reckless disregard.
I don't want to promote
you've lost your
too hyperbolic, of a slippery slope argument here, but that doesn't sound so hyperbolic to me. You're going to be required to monitor your site for sex trafficking. How far of a leap is it for a judge to say you're now monitoring your site and there's no reason why you can't be monitoring it for DMCA violations, for copyright violations, and therefore you can lose your safe harbor by over-moderating? I think that's honestly a possibility if this law is either not tailored by the states or something. I don't know. So far, the safest place in the country is Nevada because they have legal prostitution with this law. So a website operator in Nevada just has to make sure that they're only promoting prostitution in Nevada and not in Las Vegas too as well. I guess that's a possibility. Or Reno, I think, where it's illegal in both cities. Both cities in Nevada. There are only two, by the way. It's a Kafka trap. Cute. So any other thoughts? We've been here for 2.5 hours discussing law. You guys are absolutely amazing that you want to join me and share your Sunday, share your time, your attention. And I mean, at this point, I mean, I understand if you just have me on in the background, if you just want to hear this, like, while you're commuting to work or something. We're talking about super deep and detailed stuff. It's been 2.5 hours. Heck, I hardly want to play 2.5 hours of a video game, let alone listen to some idiot talk about law for 2.5 hours. So, you know, anybody who's still here, you have my kudos and thanks. So, a few other things. One, that bill has passed both houses of Congress and is waiting the president's signature, so we could still see a remarkable thing of the president vetoing the bill. I doubt it. However, of all the unpredictable presidents that I've known, I have no idea what this guy's going to do. So maybe that's the whole point. I don't know.
Keep us guessing.
But I have no idea what this guy's going to do. We have any thoughts on the stories before I set up the trivia question and take us out?
No, not really. We just had Babular ask a question. If you were paying a website to get couples together, how is that not considered the same, or what would you consider that to be?
Well, of course, that's always an interesting question. How many gifts can you give a date before it's prostitution? Usually, though, you know, dating sites are well outside of prostitution and all that. So what they have to be concerned about is if a couple of their users are taking advantage of the site and its tools to facilitate their own prostitution or others' prostitution. And if you, the site owner, if it's happening enough that you should be aware of it. So one, especially if it comes to your actual attention. Two, if you become aware that it could be happening, you probably should start looking into it. You know, because if somebody disagrees, if somebody gets hurt, first of all, that's gonna trigger a lawsuit under this, probably. Second, there's going to be people out there who want to test this. So you might, you know, Tinder or OkCupid or whatever might get a little bit honeypotted. And I do mean that in both ways. By this law, there might be people who try and see if they can test the law or find themselves in a borderline situation naturally and want to test the law. So you might see a lawsuit against a dating site or something like that. What you also will see is sites like that will probably make it clearer that if that sort of conduct is happening, to report it, they'll remove the users immediately, that sort of thing. You're just going to have to be a little bit more heavy-handed in your moderation, that's all. Again, taking you closer to that LiveJournal situation, where now you're responsible for the user-generated content because you've curated it.
Yeah.
Remember, LiveJournal did actually choose what got posted and what didn't, but the line wasn't right there. The line was a little bit before that. It seemed like there was a level of moderation that you lost your safe harbor because you had constructive or actual notice. It wasn't about the curation. It was about having notice because of the curation. Yeah, just do pornography instead, because that's legal. Can't argue with it. I mean, it's perfectly legal. Make sure you comply with 2895 or whatever it is. All of your ID document laws. That's how they get some people. Make sure you have all your documentation. Film everything. Just make sure there's a camera always running. Anyway, so we have a trivia question. Let me see if I can find it, because once again the stream crashed. I had everything prepared. It took 45 minutes getting everything prepared, and the stream crashed the minute I hit go, stream. Oh, I've lost my... Where is it? Oh, there it is. Okay. Open link. No, not open link. Copy link. So, do not answer this question in chat. I repeat, do not answer the question in chat. Okay? Do we get this, chat? Do not answer the trivia question in chat.
So I'm supposed to answer the question in chat?
No tactical
yes,
right.
So, as we have announced last week, we're going to be doing a series of trivia questions. I'm going to try to do it every week, and we'll do it in Car Talk style. If you don't remember Car Talk, go watch Car Talk or go listen to Car Talk. They're off the air now, but there's archives. They're really funny, and they did an awesome trivia series of trivia questions, and we're gonna copy their method of doing it. I think that's perfectly legal. I don't think you can copyright the method of holding a contest. So. What this is we'll ask a trivia question, and you need to email your answer to business@lawfulmasses.com. Oh, you got it. Cool. Thank you, Captain. Business plus trivia@lawfulmasses.com. The plus lets us do a filter on it. I'll be gentle. If you send it without the plus, we'll probably still accept your answer, but eventually we will filter out all the answers that don't include the plus trivia, because there will eventually be, hopefully, a lot of answers. So this contest, or this trivia question, is only valid till I hit stop streaming. It is not valid past the end of the stream. It is not valid for the VOD. It is not valid for the YouTube video, whatever. It's just for this live stream, for the people on this live stream. You got it? Okay. So, and I will leave this picture up for a little bit, so you will get a chance to see. But the question that you email us is, what is this thing? I'm providing 0 hints about this. I think this is one of the better trivia questions that we've asked so far. Of course, we've only asked 3.
Yeah.
So. So what is this thing? And I'm referring to this ladder-looking thing here. In case you're on mobile, without giving hints, I'll at least describe it. It looks like a ladder going up the side of a wall, but it's too small for a person. It has there's a hole that looks like a manhole cover or whatever in the floor, and one on the ceiling, and there's little like handles near the one at the top. It's much too small to be for a person, and there's nothing going through these holes. So what is it? Is it a... I'm not even going to say it. What is it a this? Is it a... No. What is it? You tell me. And don't even answer with those guesses, guys. Jeez. Oh well. So definitely let me know what you think that is. Joke answers are fun too, but the actual only correct answers will be considered for a prize. And I believe what we'll be doing, I'm going to announce the prizes afterwards because we do have a budget, and our budget does fluctuate. But for next week's, I think I'm comfortable saying that the winner will get a $25 gift card to Amazon or your equivalent in your country. We can send cash too, but I prefer much to send gift cards instead because they can be sent digitally and all that. So we'll figure that out. The people who won last week's trivia contest, there were 4 of you. Instead of granting only one of you the win, I granted all 4 of you $15. And I'll be contacting you this afternoon to get your contacts for sending you the gift cards if you would like. So once again, business plus trivia at Lawful Masses for the question, what is this ladder-looking thing in the center? Okay. No answers in chat. No answers in chat. You're like the people who call to my dog while I'm trying to train them. So that's our show today, everyone. Thank you so much for joining me.
Speaking of...
You can support... Go ahead.
Speaking of dogs, did you want to call in the dogs?
I could call in the dogs. They are outside, so I'll have to go get them. But let me first say thank you to our... Let me first burp so I cannot burp during that. Thank you, stomach. You can support more videos, of course, at patreon.com/ljfrench and through one of our many other methods of support that I'm not listing all at one time here. Thank you very much to our March supporters and sponsors. There are a bunch of you supporting at the $50 plus level. DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Evie, Andy, Kyle Mudrock, John H. Anderson, Vera Mintane, and Sean McNamara. And there are some new $50 plus supporters that I will begin naming on the 1st. I don't have you in front of me right now. And thank you to the 200 plus $5 supporters, $5 plus supporters, who will be scrolling on the screen when we do the video on demand of this. And I'm very, very grateful for all of you. It literally takes this whole 30 seconds of speech or whatever for that thing to scroll by. That's how many of you there are, and it's growing. So you really, I'm really super impressed and super happy. You've given me the space that I need to make more of these videos, to get better at this over time, increase production value, and increase the variety of stories that we can bring to you. So thank you very much for that. This has been an absolute dream come true. I am, of course, Leonard French, your favorite copyright attorney, and I'll be right back with some dogs, since that is the official request. Give me 30 seconds myself. Be right back. Oh, you know what we could do? I could start some light music.
I would like to ask again for you guys that are not sending it to trivia, to Business Plus Trivia, to please send it to Business Plus Trivia. It makes it a lot easier. I'm having to manually sort through some here. You have to understand that we get a lot of emails, so anything to make our lives a little easier is great.
Oh, we'll just pick you up. We're just going to pick you up. Oh, you're so heavy. Oh, you're so heavy. Oh, you're so heavy. Oh, boy. Oh, my boy is so heavy. Hello, my boy. Hello. How are you? This doesn't look terribly comfortable for you, does it? He's laying into me, though. Maybe I'll put you down and get you up to the normal way. What do you think? Huh? Come on. Come on. Come on. Hey. Oh, what you got? Oh, he's got his little toy. Come here. Nico. Oh, Nico. Come on. Come on. Oh, good boy. Good boy. Good boy. Good boy. What you got? You got a duck? You got a duck? Huh? You got a duck? Hmm? Is this your little speaker duck? Do you want to take it from me, maybe? No? What a good boy. Where's your duck? There's your duck. Okay. Yes, sir. Hop. Yes, sir. Hop. Oh, you want the duck? She's gonna take the duck. That's Yelsa. That's what she does. How are you guys doing? Are you all full of mud? Huh? I don't know if you guys saw, we do have some new dog videos out. Let me see. And of course, then here's Ilsa. And we get to discover why she's always so dirty. She's such a magnificent girl. She looks so magnanimous, regal laying there. And then... need to scratch our back. Like, every time she comes inside, her back is covered in dirt and sticks. And now I know why. I mean, I figured this is why, but, you know. Now I know why. She's really going for it. He's like kicking and everything.
How much does Nico weigh? Somebody asked.
Nico's about 90 pounds.
Is that in...
40 kilograms?
Yeah, whoa, holy crap. Leonard. Yes, exactly 40 kilograms. Jeez, I didn't know I had a 200 IQ. Got friend over here.
No, it's... I know math tricks. Math tricks... We could go over these if you really want to. There are some really cool math tricks. The way I did that in my head was by knowing the 2.2 pounds per kilogram, and 0.2 is just 10% of 2. So, you know, you can just break it down into, like, multiples of 10, too. It's really easy to do in your head.
Okay.
Some of these are just, like, Richard Feynman used to play math games in his head, like, just to, like, get the feel for things, like, just get a feel for numbers. You can actually, your brain can calculate numbers by feeling. It's really, really cool. I find myself able to, as I practice this, like, just guess, like, take just a gut feeling guess at the answer to an equation and get really close, sometimes within decimal points.
I can do that too, but I guess I just don't know the conversion for kilograms off the top of my head.
Oh yeah, so that's gonna stop if you don't know the actual conversion. There's a couple important ones that I know over the years, just as from being an adult, like 9.8 meters per second squared is the acceleration due to gravity. Water weighs 8.2 pounds per gallon. Stuff like that. You know, the square root of 2 is 1.41. These are just numbers that you come across all the time. And so I don't have to calculate the square root of 2 every time I come across it, because I remember it's 1.41 plus a bunch of decimals.
I don't know if 3 hours into our Sunday law stream is the time to be talking about
No.
I'm a little fried.
No, probably not. What I am saying, though, is Richard Feynman writes well, not extensively, but he writes anecdotes. He writes stories about his life, and in his books he writes about how he just has fun with numbers, and yes, he probably has a decent IQ. Yes, I'm probably above average, but the last time I tested it, it was not that high. Of course, it was one of those stupid internet tests, so I don't actually know. But the math is not necessarily about intelligence. Certainly, like, intelligence or IQ can help you process the numbers faster, but it's more about understanding the relationships between things around you, which is not that terribly much different than much of the rest of the human condition. Math is just taught as this dry, more than scientific subject. It's like even more boring than science. And that's so far from the truth. It's absolutely fascinating, except that we're just really crappy at explaining it and making it fun. I honestly think math could be seriously, seriously fun, and if I was a better mathematician, you'd be seeing me do a math show too. But I watch the math shows on YouTube. I'm nowhere close. Like, we're not in the same world.
What do you watch? Like Number File, 3 Blues, 1 Brown.
Yeah. Absolutely. There's a young lady who does one of them too. I don't remember all their names. They and honestly, I've been seeing a lot of stuff not be in my recommended feed. So I gotta look for that stuff. But yeah, all that's fun. Like, Richard Feynman would say, he would tell a story about one time being told that he takes all the beauty out of a flower when he describes it mathematically or physically. And he turned that around and was like, no, let me use mathematics to describe to you how incredibly beautiful this flower is. And without using actual mathematics, he described all the different relationships between the parts of the flower, and he obviously appreciates mathematics with the same level of veracity that some people appreciate religion.
Yeah.
He's basically, you know, a fundamentalist when it comes to the religion of math.
Well, one of the things that's always been impressive to me is, like, the Fibonacci sequence being in nature
Yeah.
very often, and we don't really understand why this is. It just is. Like,
The rule of thirds is another one. I was driving around yesterday and wondering about the climax in a particular song. I was thinking about the song from Moana. The one, I forget what it's
What can
called,
I say?
but the one where she wants to leave, the one where she wants to leave the island or whatever, and it's it climaxes at the end, and not like in the middle, and it's supposed to climax in the middle. And the rule of that, I forgot it. I forgot like what it was, and I realized it's a rule of thirds. The climax is supposed to come 2/3 of the way through the piece, and then a reprisal of the climax comes at the end, or not, depending upon how you're writing. But like a lot of things are governed by simple mathematical rules, not like some of them are natural, like Fibonacci sequence and the rule of thirds. And some of this explains a lot. You can be religious about mathematics. What is religion ultimately but the wonder and mystery at the world around us, where we came from, where we're going, what our purpose is? Mathematics is the language that describes that.
Yeah.
It's the most precise language that describes the relationships between things around us. So I honestly have no problem understanding how you could get so passionate about mathematics. And what bothers me is that it has been so... I'll stop. Maybe stigmatized is too strong of a word, but it's been definitely stigmatized into like being not as fun as science, and even science is not as fun as technology and engineering, and even engineering and technology aren't really fun. Like, that's kind of how it's been presented in academia these days. You have to already know about science, technology, engineering, and math in order to be interested in science, technology, engineering, and math. But then again, I'm also out of school for a generation, so maybe things have changed now. But
yeah, if you guys really want to get into maths on YouTube, look up Matt Parker, Vihart, Numberphile. They're all on Numberphile at some point. There's a lot of stuff. They make it really fun. You know, you learn a lot, and you can see how that stuff applies in nature and stuff like that. So.
all right, well that's our show. We've got 1 minute left on the music. There are still 120 of you here. Oh my God! And go have a great Sunday. We'll let the music play itself out, and I'll try to get the dog back on that.
Oh yeah, go boy. Yes, 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 yes.
Yeah, that's a good way of saying it, Kotaku. Math is often not taught, they teach calculation. Yes, that's how math was mostly taught to me. The most compelling math teachers I had, they taught the relationships. They taught the math too, but they taught the relationships between things, and then used the math to show you how to describe it. One of my favorite math teachers ever was also a baseball coach, and he would put the grid up on the blackboard and then walk to the back of the room and pitch the chalk at the chalkboard and make this big boom of chalk when it hits the chalkboard, and that would get everybody's attention, and then he'd go and describe the mathematical concept that he wanted to make. I was very much appreciated Henry Kep. He was a great math teacher, as well as Shailesh Nair, who was from South Africa, I believe, or I don't even know exactly where in Africa. He was obviously African. He had an South African accent. He pronounced reciprocal, and I was got a kick out of that. But in 5 weeks, he taught me Engineers Calculus B, or Calculus 2, and I got a B. And that was my highest grade in a math class ever. So it's about the teaching, and it's about the methods more than it is about teaching kids 2 + 2 is 4, 2 + 3 is 5, 3 × 5 is 15. Like, I had to memorize all that, but it didn't teach me the relationships. They really should be teaching the relationships. I think we completely overlook the right brain sometimes, but we're at the end of the stream and we're starting a whole other conversation.
Oh my lord.
So I love you guys. Have a good Sunday, and I'm going to go have a good Sunday too. And say goodbye to Nico.
Bye.
Bye, Nico.